Hi, everyone. Sorry, I totally have you guys on my lap right now. I'm waiting for my desk still. And yeah, so that's life in the moment. But hi, everybody. We got lots to talk about today. Okay, cool. I'll send you guys links. Give me un momento, por favor. I have not used my computer in quite a few months, and I am not signed into my emails. So let me see if I can text them to you guys. Maybe that might work better. Or actually, hold on. Let me sign into my Gmail. Let me see if that works. So I saw Helena Rafferty, by the way, going into the court. So I suppose that means that she's also going to announce that she got the phone call about the federal investigation being over, the witnesses being cleared. The CPD got the call, the MSP got the call, the DA's office got the call, and the witnesses got the call. So okay, let me do that then. Let me text it to you. So hey y'all. So I have been telling people since last year it was over. Nobody wanted to listen. It's on them. And as we know now, it has been over since last year. So yeah. The sound. Ooh, am I having a sound? I also can put my headphones in if it's not. My sound's all the way up. If it's not loud, I also have it on my lap. I might be blocking like the microphone or something by having it on my lap. Am I not loud enough, you guys? Am I not loud enough? Is that like not a thing? All right. Just tell me if I'm not, because then we can fix it. But I expect today that Hank Brennan will make the announcement and the judge will confirm said announcement. And I also expect, in my opinion, the judge can't do anything less, in my opinion. I don't think sanctions of the giving Jackson a good talking to is going to work. She's given them a lot of leeway, like quite a lot of leeway. And if she doesn't put her foot down, and this is all like on the up and up, as we know it is, but like, I have to say that for disclaimer reasons, but it's on the up and up. But it's like, I don't understand what they think was going to happen. Did they think that like he was just going to be able to like lie to the judge and like that was going to be like easy peasy lemon squeezy coolio? Like, you know what I mean? Like that's not, no. Like that's just not how it works. Like sending. Oh crap, how am I going to send it to B Tim? I can't do that via text message, just in case he wants to pop on. He's always there. Good, something good to add in, I feel like. See if I can sign into my email just to send him over a link. But anyway, I expect that Jackson's, in my opinion, what should happen is his pro hoc vice should be pulled. You are practicing in another state as a courtesy of this state, and you lied to the court, to the judge. Like, that's a big fat no-no. Like, a literal big fat no-no. Like, you can't, that's not a thing. Like, so it's like, in my opinion, that's what should happen. Hold on a second. Oh, you know what? I don't know why I'm trying to do this from my computer when I can just do it from my other way. Hey, freak! I missed you guys. I did. I missed you guys so much. You guys see my new sign? Right. Justice Act. I actually have like a thing that I bought that I have not put up, but I think we should do this today because it says do epic shit. I'm just saying. That's what it says. It's glowing. It says do epic shit. I think we should do some epic shit today in this courtroom. Because I think that's going to happen today in this courtroom. Like, there are some shit's about to go down, in my opinion. Just saying.
Hey. God, you look good, girl.
Oh my God, thank you. I like my medication. I went down on how much I am on the medication, and it holds a lot of water weight. So I have lost a few poundages.
Oh my God, you look great.
Thank you. I was hoping that like it was noticeable. Sometimes it is and sometimes it isn't, but it's been quite a few months since I've seen you. Well, actually I saw you guys in December on Roy's channel, but I have lost a few poundages. Like well, see, here's the thing. TR 1991. I have a channel, so I'm allowed to like totally give my opinion whenever I want. And so I'm doing that right now. And my opinion is that Jackson's pro hoc VJ needs to be pulled if he lied to the court. Like he lied to the court. It's not hard. It's not Judge Cannoni can't just give him like a strong talking to, and I'll tell you guys why. He can't give him just a strong talking to. First of all, wait a second. Does anybody know what channel is streaming this so I can like get that on my other thing here? Is it channel 10? Anybody know?
I'm not sure. That's why I came here.
All right, hold on. Let me pull it up on YouTube. Oh, it was Fox 25. That's what it was. Sorry. Sorry. It's Fox 25. I saw it yesterday. It said at the bottom of their little article, Fox 25 will be streaming this. Like, oh, okay, cool. Thanks, Fox 25. Maybe you should have gotten what I want to see happen is I want to see I want to see a U.S. Attorney's Office make a damn statement. Like, you know what I'm saying? Make a damn statement, dude. You guys created this mess. Like, in my opinion, you allowed Levy to do what he did. It is your job to clean it the F up. Like, clean it up. Make a damn statement. Like, they know nothing less than that is going to satisfy the mob. So, like, why not just
talk about how rattled Aunt Bev was when she went to went to her judge's podium?
Because I want everyone to remember that the way, hey, Kathy, the way that she said, and the way that she said this is like very telling. She said it could have profound effects on the defense and defense counsel. And there's a reason why, because she can't just slap him on the wrist if he lied to the court, because that invites other like attorneys to do that in her courtroom, and all they'll get is a slap on the wrist. If this is what you're going to do and you're going to misrepresent, like, then you should expect to have the book thrown at you. That's, I mean, in my opinion, she can't really do anything less than that. Like, she just can't. Like, that's, I'm sorry, but like, that's the reality.
She was so flustered. You could just tell that it was the disrespect that was done to her courtroom.
Yeah.
And the disrespect that was done to the robe, in my opinion, when she went up there. Because in the end, the judges are there to uphold.
That's right.
The court and the rulings of the court. They're just the vessel that delivers the ruling. The court is higher than the judge is.
That's right. Like, and so for me, it's like the judge can't just give a good talking to. Like, that can't happen. Like, because that sets a precedent for anybody else in her, in her orbit. Like, if
anybody coming into her courtroom in the future, it's okay to lie to this judge.
Exactly. This judge will let you get away with it with a stern talking to. And because she's already given them so much leeway. Court TV has it scheduled for 11. I'm not really sure if what they're doing. Like,
I did hear Mr. Riding Dirty in the Z28 saying that it started at 11.
Yeah, it starts at 11. But I don't see it
on time.
I don't see it anywhere. Like live stream besides Court TV, which I have up right now on my other screen here. But like, I don't know if they're going to cover the entire thing or they're just going to cover a portion of it. Like, so for me, it's like, I need to get something that's going to cover the entire thing.
Yeah, I'm going to look. I'll look right now to see. Because I know it's hard to. Yeah, this judge has to do something after the dramatic performance on the whole thing. She's got to do more than a talking to.
Yeah, it can't just be a stern talking to. They literally can't. It's just not like a thing. Like, if she does that, law and crime, she's going to look so like a pushover. Like, and it's like, she's already given them so much leeway when it comes to like stepping over that line or stepping on that line. Because in my opinion, they've stepped over it quite a few times. She's even denied some of the like actual like motions that were pretty straightforward when it comes to the Commonwealth. And I'm like, why would she deny that motion? Like, that doesn't make sense to me. Like,
hey, I just found a Boston 25 interview for you to play later.
Okay.
I just sent it to you on
I don't
text.
see it on Long Crime Trials.
I got it right here on Long Crime right here.
Okay, because I'm looking there and I see ASAP Rocky
Yeah.
and everything else.
Look who it is, everyone. It's Fanny.
The fan's back.
Oh my God, I missed Fanny so much.
It's Fanny, man. Oh, hey, Kodo. I miss you guys so much. I don't have a desk
It's
yet.
good to
I've been
see you
waiting on this
back. You
desk
look good,
for, like,
Elise.
a month, bro. I've been waiting on it.
You-
Like, I need this
You
desk.
got a
Like,
box? Do you got to
Good.
stack a couple of boxes
there's
together
a
to set
chair.
it
I
on?
have like I have high top like bar stool chairs, like and that's what it's on right now, but it's like way high up, I feel like. And then like when I close my curtains, I feel like there's not enough light for you guys to really. It's like shitty light in my living room. I don't know what the deal
That's
is going
okay.
on.
It's fine. You're fine.
Yeah, you look good. You do.
It's
You
not
look
up
good.
too high. You look good. You're
Mhm.
It's just because you haven't been doing this on a regular basis. That's all it is. You're
I know
fine.
that is. I'm out of my funk because I haven't been. That's why.
Well, it's good to have you back.
I know. I missed you guys so much. I missed everybody so much. I know. Thank you, Anna. I do. I missed you guys. I mean, I talk to Freak all the time. Like, you know, you guys can always get a hold of me on Twitter, you know, and I know that would be amazing, Freak, if anybody could say their full name without the hordes of the cult chasing them to oblivion.
Hey, Elise, look at your screen. Is there a watermark in the upper right-hand corner where your Twisted Tragedies is? If there is, you need to take your Twisted Tragedies off because
I don't know.
Yeah, put it down. Yeah, don't
Yeah.
cover their watermark.
don't
Wait,
cover
how
their
the hell
watermark.
do I do that then? Hold on.
It's going to be over on the right-hand side. You're going to go under brand and
Style, media assets.
I mean, I don't know
do
if they do anything, but I've seen other people get in trouble for that. So
yeah, we don't
I
want
don't
that.
know.
We'll move ours just in case. But I just gotta. Oh, no, I don't see a watermark.
It's got okay. Well,
Nope.
just don't put yours up there right
Yeah,
now.
I'll just leave mine off.
This.
Yeah, I'll leave it off.
We don't because then that makes it look like
Yeah.
And right now they're hitting people with demonetization.
I've already been demonetized for something bullshit when the cult like reported me over and over and over for like literally nothing. I've never even have a video taken down before. Like,
So
I've had one
demonetized?
video ever. Huh?
You're still demonetized?
Yeah.
Oh,
I mean, I can
that's
reapply
insane.
now. Now I can reapply, but now I have to like push my metrics because it's been more than 6 months. So now I would have to like, you know, I'd have to like restart over with like my metrics before I could reapply, which is just so stupid. But I quit smoking. I only vape now. Isn't that amazing?
Good for you.
I know, right?
I still smoke those couple cigarettes a day.
I'm not monetized. I know, right? I am not monetized, so you can't do super chats or super stickers or anything like that right now. But you guys can always Venmo and Cash App and PayPal, and all that information is the bottom of the screen. Just scrolls on by in little tiny things, like, you know what I mean? And I well appreciate it. I mean, it's funny because like I'm such a small channel. I mean, most channels start small anyway, but like I think back to like what my money goes to when I get donations, and it's like my money goes to like literal like food, like toilet paper to wipe my ass, like shampoo and conditioner, like my kids' new socks, like. And I mean, most of you know right now, like my oldest daughter is in the beginning stages of bone marrow transplant, so that has been a long road, and we've been in and out and in and out and in and out of the hospital, and I do want to tell people though that I didn't know this before. I do now, obviously, that if you want to donate bone marrow to anyone, there's actually a bank. There's a bank. It's swabs. It's just 2 swabs in one side of your mouth, 2 swabs in the other, and you send it back, and then they keep that so that if you match someone and you do want to donate, back in the day, it used to be like an invasive surgery. Like it used to be pretty invasive. Now it's just 6
they did a hip core.
Yeah, they go in your hip, and it's like 6 to 12 little tiny holes. You don't even need like stitches, I guess. Now it's so small. Like, and your bone marrow, it regenerates. So like, even though you're donating it, like you're gonna get like your bone marrow basically back, even though you're donating it to save someone else. So
we went through that with my brother.
Yeah, I mean so that's the thing that we all did. My family, like all of us, got tested, but the chances that I would be a match or low because I'm the biological parent, and usually the
Right.
biological parent is about a 50% match.
Right.
She doesn't have any full siblings. She has half siblings. And so like the chances of a half sibling being a match are about 33. It's lower, 33% or lower.
Right.
So
My brother was lucky. There was 3 of us that were awesome, spot on matches.
see, that's perfect.
We were
So
lucky.
basically
Yeah.
for us, they said, you know, the best chance is probably a stranger. But of course, my daughter's, you know, boyfriend, friend, a couple of her friends, and my husband, who is not her biological father, but her father to her, all got tested, but we won't know. It takes 8 weeks apparently to get our results. So, we won't know for a while. And again, we're in the beginning stages of this whole bone marrow transplant thing, but, hopefully it goes well and can resolve some of the, you know, lifelong issues my kid has had with her rare disease. And she was just diagnosed with progressive scleroderma, so that really put a gas pedal on doing this bone marrow transplant now. But I thought it was.
Can you tell everybody?
Are they talking about stem cells?
So she has what's called, I think it's coming on, STAT3 gain of function. Less than 200 people on planet Earth have it. All right, let's turn this on. Hold on. You guys can hear, right?
Oh, this judge.
And can you drop the comment, please?
Oh, yeah, sorry. Let me see if I can turn this
It's
up.
really low.
Yeah, hold on.
Morning, Ms. McLaughlin.
Let's go all the way up, dude.
Good morning, Your Honor. Hank Brennan from the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little. Also.
Turn it up on your
Good
laptop.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf.
It's all the way up on my laptop, too.
Mr. Lessie.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right. So last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There is another email that was 2 days before the trial and 2 days or after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talk to. I looked back at the June 18th Voire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you? Bring it up.
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
He just wants to talk and try to confuse, but unfortunately, the judge clearly doesn't even need to hear from defense counsel, which speaks volumes to me.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay.
He was stressed last night. He must have been up all night.
You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
Oh, good. We'll take 5 minutes to talk about it. Fantastic.
Hey, maybe we should
Oh,
try
let me
to
mute that.
maybe we should see if we can get that one that
So I checked, but it didn't seem like it was much. I'll switch to it, but it didn't seem like it was much.
Okay. Okay.
Hold on. I'll get. Oop! I had it up on my screen. What happened? Where did it go? I did. I don't know if it's my computer, maybe, and that's why it's just not. I don't know. Usually, I don't have a problem with my, volume. So I don't know. NBC 10, WJ.
I think it's on their end.
Maybe. Let's see. Okay, we'll do this one instead.
This judge takes too many dang breaks.
Yeah, you can say that again. She really does. Does that sound louder? Even the noise in the background? Or no?
I can't tell.
I can't
I
tell.
can't tell. It didn't seem louder, but we'll switch to this one and then follow it on that one. But wow. So I think it speaks volumes that she doesn't even need to hear from defense counsel because, as she said, it's all right in front of her. She went back and read it all. She saw the transcripts. He did mislead the court and the judge. So it's like she doesn't even really need to hear from them. I find it funny that Alessi wants to speak for Jackson. You're not saying that you're representing Mr. Jackson or the defense in this matter. You just want to speak for the whole defense, even though you weren't there and weren't a part of it. I find that weird. But I also feel like, and I said this on my Twitter, that we all knew they were going to try to word salad their way out of it, distract, complain about the Commonwealth a little. Oh, the Commonwealth did this, the Commonwealth did this, the Commonwealth did this, which has nothing to do with this at all. And then, you know, and then try to get like weasel their way out of a bigger, you know, slap. And I just don't think that that's going to happen. No matter, and what Alessi's going to do, and mark my words, is he's going to sit there and talk and not really say much of anything, because that's what he does. He talks and keeps it going like the friggin' Energizer Bunny, but he doesn't really say much. He says the same 6 things over and over and over and over. Like, just, it's literally a distraction method. Yeah, they won't believe that the Fed investigation is over. They still don't believe it, and it's been reported everywhere. I find it funny, though, that mainstream media took an extra day to catch up with the fact that, like, I reported this. Like, I literally got the information. How do I say this? Like, I got the information before mainstream media, and I knew with 1,000% certainty that it was good information because of where I got it from. Let's just put it that way. I have sources, bottom line. And I already knew from a different source last year that it was already over. This, though, was a phone call that was made to the witnesses, to the state police, to the Canton PD, to the DA's office. So numerous people were called when this call came in about the feds. And one of the things that they said was the witnesses were all cleared. They were all cleared. Okay. The cult refuses to, acknowledge that. But they were all cleared. It's literally that simple. It's kind of sad, though, that like here we are, right? We know that the federal investigation was ended over about February 2024. Around about February 2024 was the last action they took on it. There were no indictments. Nobody was charged. They found no corruption. They found no cover up. And no, they did not find Karen Reed innocent, or she wouldn't be having this second trial. That's not what they were investigating. And I would like to point out that the part of the U.S. Attorney's Office that was investigating was the public corruption unit. It had nothing to do with whether Karen was, quote, innocent or not. They wanted the public corruption aspect of it. And they were able to clear the witnesses and, here we go, clear everyone else that way.
Is she going to sell her clothes again this time?
Unmuted.
No.
No, the other side too.
Also, thank you for the $20 PayPal for breadstick money. I appreciate you, because funny or not, it's actually going to breadstick money because I have no damn food in my house, and I kid you not. Like, yeah, that too, Ellen. Yep. Oh, they just keep pivoting.
Right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
I know, Bree. I know. I feel for her too. Yes, thank you for the breadstick money. I appreciate you. In reality, it is going to go to food. So I don't get paid till Friday. I'm a poor person, remember? People like to throw clock shots because I'm poor. Like, so I never claimed to be rich. I'm poor. Thank you. I know. But my family's also a hardworking, poor family. We pay taxes. Thank you.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components.
What?
And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning.
Oh boy.
The notebook is purposefully in chronological.
Oh, come on.
Turn your pastime.
And no, I'm
into
sorry. I do
full-time.
not have pro.
Your personal.
I'm a poor person.
Proper chronological presentation of the facts.
Alessi.
I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns.
I knew it. They were going to try to go after the Commonwealth.
Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor. And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you were addressing this in chronological order as well, right?
Yes.
So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them,
Sure.
but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your
I
number.
will tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to this is tab 8,
Right.
the notebook.
Mhm.
And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So
We know what the facts are.
Your
Thanks,
Honor,
Phil.
that you would like me to
You
suspend my
can
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read at
Gaslight.
certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Lessie.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts, but I want to go backwards to start in terms of something that is well known, and that is the federal investigation
Is over.
and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as your honor will recall, the trial one started in April of 2024. So it was pretty close to when that trial started. And I know your honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report, that the vehicle, and the substance is important, your honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Miss Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth.
He has said
and to the
nothing
defense.
thus far. Nothing.
Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them.
No, they
Now,
didn't.
only the Commonwealth knows why.
Protective
they
order,
didn't take that
dumbass.
Opportunity. It may be because of the findings. It may be for other reasons. I don't know, but I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts.
They couldn't. It was a
The
federal protective
defense
order.
surely did. So that is the background. That is
Oh my God.
the information that we have.
This guy's an idiot.
And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed.
No, it's not.
Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as your honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law.
You think?
Meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1.
The defense.
It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important?
Yannetti's not absolved.
When we get to Massachusetts Professional Rule of Conduct 3.3A1,
right.
That fact is going to become extraordinarily.
He has to oversee it's his job to oversee Jackson, so that's completely false.
So we have
He's not a state attorney.
Communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope.
Mr. Burns is her dad
they're
back
not
there.
going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope. There was certainly the desire, but there was no agreement that they were going to be testifying. That was
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial.
Correct.
Was that in effect at the time these emails were sent?
The answer is, Your
Yes.
Honor, and I'm going to get to it.
Yes.
I'm going to answer your question.
I'd like you to answer my question.
Yeah, no, I wanted to say.
No, just answer it now. That's what he wants now.
What Mr. Yannetti articulated is the rule of the road, not prep. Was
What?
not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The
Ugh.
rule of the road was there would be no
Please.
substantive conversations with the ARCA experts.
And you had substantive
Okay,
conversations.
that was
Stop
it. But the answer to your question is I do not know.
Then ask.
whether the ground rules were in effect, but I can get you that answer, and I will
How about
give you
right
that
now?
answer hopefully in moments during my presentation.
No.
But I do not know the answer.
No, now.
All right, go ahead.
And it's an important question, important answer, I understand.
She wants the answer now. That was the point.
But I'm going to
Idiot.
give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the
don't give her the
logistics
answer
for your
now.
preparation.
The answer is
in
yes, it
trial.
was in effect.
Yeah.
Then we get to the email up above,
And it's not
and
rule
that
of
is
the road.
merely 2
was an order.
days later. Again, Mr. Yannetti is not copied on. the
Doesn't
email.
matter.
And my understanding is Mr. Yannetti is not knowledgeable about these communications. So
I'm dead.
the email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it."
I know.
Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly in code at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So
Are they forgetting
what
the
happens
script?
is I call this the pause
Apparently.
email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc.
No.
And then we have
Can't
the
talk your way out,
pause.
dude. Sorry.
The next tab is tab 2, which is the very important June 10, 2024 transcript, excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only
It's irrelevant.
for the
That's
non-evidentiary
irrelevant.
transcripts I reviewed was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor.
Because
Why
it
do I
answers your
underscore
question.
this point?
It isn't a point.
Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying.
You did.
The two most powerful witnesses in
They weren't
support
powerful.
of the present.
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get that.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Me
And
neither.
so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying.
It's irrelevant.
If there was an agreement
When you did
that
know.
they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on.
It took all that to get to the predicate. He's saying a bunch of irrelevant stuff. They still lied to the
This is
court.
tab
Period.
2,
Yeah,
page
this is
28.
nothing but a bunch of fluff.
There's nothing he's saying here that's
Line
relevant in
5.
any way.
The court.
Mm-mm.
Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is.
That's what she said.
So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court. And it's important not to stop there.
Right, Karen,
with what
he has
Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair.
You want to key into the judge's words?
Your
As if your
question-
words
That's
tell
exactly
her
what I
words?
said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right? To and putting them on the
Knows
stand.
what she said. That
Now,
is so
no one ever
crazy.
said from the defense they never spoke to them,
You're patronizing the judge.
but that was what Your Honor was concluding from what was stated.
Wow.
So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if
Dumbass.
there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says that's essentially it. But what follows is really probative.
No,
We've spoken to them
it's not.
only for the purposes of coordination of their testimony.
That's where he's going to try to play word salad.
And their
Mhm.
background. And I've got definitions of coordination and background.
Oh
that
my
I won't
God.
provide, but those in Merriam-Webster's dictionary have specific meanings.
Here we go. She
But I
knew they
don't
were
have
going to try to do
parse
this. She's
that
not
at
an
this
idiot.
point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there. It might be at this point. Wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor. And this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify, yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's Mr. Yannetti says that is
irrelevant.
Fine. So I said I'm not going to conflate issues.
You are
But there's
conflating.
overlap of issues.
No, there isn't.
So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page,
It's tab 3. and It's
FYI,
the June 18,
Okay. Until this
2024 voir dire examination.
he has said nothing of
Of-
substance. Nothing.
Dr. Wolf.
Legitimately, nothing.
And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire.
They didn't have the
Your
information
Honor
to ask,
set no
dumbass.
limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise.
You would have known if
There
you were
was
going to pay
no
them.
reward.
Stop it.
There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense.
Wow. Acting like the fucking judge
There
is an
was
idiot.
no
Idiot move.
favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses.
Oh, I fell asleep. Shut up.
And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell.
Is he calling it a wah?
That was the opportunity. They had a
Voir dire.
Dr. Russell
Like wah?
opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions.
They
that
didn't ask
someone with the
questions.
benefit of my
We didn't
hindsight
know
and
that you
Monday
were
morning
lying.
quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask
They
those
didn't
questions.
know you were lying.
Had they asked those questions,
Dumbass.
they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note.
Family proof your family with Place Alerts by Life 360.
Well, ever since he was a baby, they knew the kid was cowboy crazy by his head.
Restrictions, opportunity to ask whatever they wanted to
blocked
ask.
by accident.
And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4.
I'm trying to find out right now.
Tab 4 is the June 22nd, 2024 email.
I haven't
But
blocked
it's
anyone yet today.
important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares
Aware
it.
of who prepared it, dumbass.
He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolf's experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf direct, attachments Wolf direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment.
Oh, man.
Of ARCA.
Trying to figure out if someone was
The
blocking it here.
frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
She's not an idiot, dude.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom.
That you're an
is that
idiot?
Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered.
Patronize the judge. She's over it.
I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18th
Doesn't matter.
hearing was,
He's
what's
responsible.
the day, et cetera, et cetera. And I'm
Yanetti's
going to get to it.
responsible for
And
Jackson.
I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing because I think this is very important for the Rule 14 issue.
There's no
This is
jury here
Sunday,
today.
June 23rd at 2:59.
It's just a hearing,
p.m.
not the trial.
The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024.
The judge is over this.
The
Just so
very
you
next
know.
day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline or from Mr. or Dr. Wolf to be able to prepare one of the most important direct examinations of the trial
Oh,
until he
please.
got it.
You got
I
caught.
think that
You're just
person would
mad.
have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is
Was this
that
written by
this
Alan
was
Jackson
something
for him to
provided
give?
by Dr. Wolf, not drafted one word by Mr. Jackson.
Irrelevant. He still misrepresented
So
to
if
the
someone
court.
is to say
Come on.
that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation.
You just say
this
Brennan,
should
you
have been
pussy.
turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters,
Please.
under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation to basically say, I don't, as the court, understand. These folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor.
Bro.
But the question is, what's the prejudice from not getting those emails?
Fair trial.
In light of the voir dire that Your Honor ordered.
Trial.
We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth.
Legit.
So now we have the trial testimony of Dr. Wolf.
Yeah, the email on YouTube.
I
is
mentioned, Your Honor,
weird.
about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred.
Oh my God.
As I mentioned earlier, a great deal of my work is in the field of lighting and visibility.
I'm dead.
So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my case. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Miss Little? No. That's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct.
And none of that's relevant.
Page
No.
3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct.
It's not correct if you paid them. Sorry.
There was no engagement.
Doesn't matter if you paid them afterwards.
There was no engagement letter signed. There was no retainer.
Well, at that time,
Those discussions
they didn't work for
that
them.
were started on
Right.
March
Well, but
20th.
that's the thing. If they knew they were going to pay them later on, it's still
To the March
disingenuous. You still lied to the
22nd
court. The judge
email.
isn't an idiot.
And they
And no
never
expert witness is going to testify without being paid.
Right. It's
They were
common
never
sense. That's the thing.
re-engaged.
Nobody's going to
We got-
testify
we
without
got
being
to
paid for their
eventually
time.
Get them on the stand, but there was no retainer. There was no terms of the engagement.
The expert witnesses didn't even get to testify at our hearing, and they still got paid.
Right.
So then the next, that's correct. Question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct.
Oh my
Mr.
goodness,
Wolf
idiot.
sent in questions that he proposed Mr. Jackson asked. But that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson.
We
It's
know
not
who it came
Mr. Jackson asking questions in that
Oh
document.
my
It's
God.
Dr. Wolf sending them in.
Doesn't matter.
And Your Honor,
You had to
I'm
turn
gonna
them over,
speculate if I could, and
regardless.
I'm not going to do this often in my presentation. But I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position,
No, please.
we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country.
But he never heard of it. What do you mean?
He is an
Never heard of the
experienced
case.
expert. He's used to interacting with
Just said
attorneys.
that.
He is not having the level of interaction and preparation anywhere near
He's
what
bad
he's
at
used to
this.
having. But he's got to go on the stand with his professional reputation, and he's nervous.
Because he
He's
lied.
nervous.
That's why.
So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits.
Thank
okay?
you.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I
If
said
you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate.
Oh, you're
I said
lying once
I
again.
was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
No,
Okay.
you don't
Because
speculate.
The Commonwealth on the 18th speculated a lot. And I
Okay.
think the only way to fairly.
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
Here, I will tell you the basis
No.
of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious.
Why can't Mr.
about the
Jackson
fact
speak for
that he
himself?
had to get on the stand
Just saying.
without having the typical level.
How would
of
he know that?
preparation
Unless he
and
had a
knowing.
conversation with him, though. You
That
idiot.
is Mr.
You're bad at
Jackson's sense of
Sense?
Dr. Wolf's situation at the time
So he
the
speculated.
direct was sent.
He's bad at this. I'm just saying.
Can I say for certain? No. Can even Mr. Jackson say for certain? No.
Then why are you saying it?
That's the sense, though, that was
Okay, a sense and a fact are two
at
different
that
things there,
particular
but I have a sense that Karen and
So
Turtle
we then
are
go
both
down
very, very
to the
guilty.
next question.
Moving is the point.
But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're
Right.
testing
That's
before.
for a literal
That is
living.
correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you join us and testify. Correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA.
No.
That was Dr. Wolf's sense as well. So
False. It's a lie.
that is the direct testimony of Dr. Wolf.
Yes.
And I want to just speak to the findings because
did,
on
Bree.
page
And you do an amazing job.
3676 to 3677.
Piss me off.
Because the findings never changed one iota from the report ARCA issued.
They would if you gave
in
them the text
February
stream data
to Dr. Wolf's testimony.
and the rest of the
There's been
data.
a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified.
He's deflating.
And the key emphasis, and I think should be the key
Hey, Willis,
concern of
Mr. Burns.
everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that we
Thanks
have.
for admitting that. We
So
appreciate it.
what were those findings? Bottom of 3676,
Get an
line
accident
25,
check,
did you
Mr.
perform
Burns.
an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes. I think that's a fair characterization. And reversing that was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being
It literally
hit
does.
by
Take an hour to warm
vehicle.
and actually even say one
So
sentence.
it's important to know in terms of,
Bingo.
you know, whatever the interactions were and whatever the effect of the interactions were,
The
is
effect
that the findings
of the interaction?
always stayed the same.
Doesn't matter what the
was
findings are. That's
elucidated
not what
at
we're
trial,
arguing
what was
here.
Presented to your court
I don't think so.
was not anything whatsoever different from what was established in cement
Does
in
he
that report
even know
in
he's
February
supposed to be arguing?
2024. So now we go to, and of course, you know, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred
We're not
were not the
arguing that.
result of an interaction
Inconsistent
with a
with.
motor vehicle.
Not
So now we go,
inconsistent.
Your Honor, to the tab 7, which is the invoice.
Oh God, someone save me
I am
from
going
him.
to be very precise and
Like,
point out
You're gonna
some
word
items,
salad. Sure,
hopefully for an efficacious purpose.
sure. Word salad it.
It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over.
Someone save me.
Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice.
You don't? Seems like that's
But it's
what you're
important
doing.
to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March And it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial.
Right.
I'm not speaking with firsthand knowledge.
Yeah,
on
so
any
shut
of
up.
this.
Why is Jack
But
speaking
I
for
have
himself?
conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications,
No, please.
but I can tell you there's one person that was more shocked than most about the invoice coming in.
Oh,
and the
you?
amount.
Oh, please.
So what happened? And this is, Your Honor, objective. These are recollections,
Not objective.
information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this?
What is what?
Can we pay it? We supposed to pay it?
Oh, please.
I encourage Your Honor to communicate with the U.S. Attorney's Office.
Pretty sure she has.
about,
Genius.
did this conversation really occur?
Pretty sure she did.
What was
Genius.
the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this?
It's irrelevant whether
Are
you
we
paid
going to
it.
be
Still
in
lied to you.
violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay it. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Jackson said he didn't pay anything. Nothing was paid.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best
You
of
shot
my
yourself in the
understanding
foot.
Was very close in time to when it occurred. So I understand the date of this invoice, not understand, the date of the invoice is July 12th. And I think I can get you.
Wow. Talk about shooting yourself in the foot, you dumb fuck.
The
Jackson told
Mr.
the
Jackson's
media
firm, not
it
Mr.
was
Jackson,
not
but a staff
paid.
member.
Absolutely
And I
not.
want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in.
I love
And I
it.
believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th.
That sucks to be.
And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter.
You guys knew you were going to have to pay. Stop it.
When was that? Within a week within that July 24th date?
Get you an exact answer?
I would like that.
Sure.
Yeah, you paid.
I'm going to
period.
attempt to get an exact.
Why
if I
hasn't
can,
it been
I
told
think I
to
can
the
get it
defense
for the
up
trial.
until this point anyway? It's the point that all that was hidden. It has nothing to do with whether it was paid or whether it wasn't paid. That's irrelevant, but it's even funnier that it was paid. Look at Paul's face. I wish they would zoom in on Paul's face. Yes, Paul, yes.
Is he wearing a
Your
diaper?
Honor, I understand a check was sent to ARCA.
The
on
blue
July
shirt?
25th.
Thank you.
You're welcome.
in memory of his brother.
So there's no doubt the invoice was paid.
Oh, Jackson said it wasn't to the media.
But the story is
Ouch.
not solely about was the invoice
No,
paid.
you're right. It wasn't about you lying.
The important part of the story, what the facts, is it came out of the blue.
He keeps arguing against his own
And
arguments.
I don't expect anybody to take my characterization 100%.
Okay.
But that's my full understanding. But the
And why
call
are you
to
making
repeat
it?
to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question. And it's important, very important question. But it's an important fact point as well that call was made.
Jackson should speak for himself then.
In terms of the next tab, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I was just going
that.
to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
That's a great idea, Your Honor. I have a lot to say to my audience.
You are muted.
Hold on.
You are unmuted.
Yeah, let me get this muted. Oh,
That was a whole lot of.
that was a whole lot of nothing that was said. He
Yeah.
literally just argued against his own arguments 72 times. He argued that it hadn't been paid yet and they didn't know and they blah, 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 but then argued, oh, yes, it was paid. He seems to forget that Jackson told the entire media that no, it had not been paid. Nothing was paid to ARCA. And if you expect a judge to believe that you were getting witnesses, no matter how you were getting them, whether it was through the federal government and they were their witnesses first, it doesn't really matter. If you expect the judge to believe that you had no idea you might have to pay experts, like you're just literally spitting in her face at that point. Like she let him go on and on just to give him the courtesy. But I could tell, like, from the time she interrupted him, that, like, you're first of all, you just patronized the judge by telling her what she said. She knows what she said. And then he did it even more by then trying to assert what the judge meant and what the definitions of those words are and how the judge meant them. You don't get to decide what the judge meant when the judge said it. She knows damn well what she meant when she said it. There was a whole lot of words coming out of that man's mouth. And just like I predicted, before he started talking, he was going to talk and talk and talk, but not really say much. All he did in that last hour was shoot the defense further in the foot. You paid an invoice. You still hid the fact that you paid the invoice. You did talk to these people, and you still hid the fact that you talked to these people and that there was an outline. You needed to turn that over, and you knew you needed to turn it over. You still didn't turn it over. The crux of this whole thing is you should have turned it all over to the Commonwealth, not hid it. So no matter how much he argues, like, this happened on this date and we didn't know they'd be testifying, it doesn't matter. As soon as you did, it was your job to give it, period. No ifs, ands, or fucking buts about it. Like, so you're just repeating things over and over that don't matter. That's not, we're here today because you misrepresented to the court, period. That's it. Like, it's not a hard thing. And then you just shot yourself further in the foot. Now, here's the funny part. He wants to keep asserting that nobody should take his word 100%. Then why are you speaking on behalf of Mr. Jackson or Mr. Yannetti? If I was the judge, I would have stopped him right when he said that and said, okay, well, if you can't give me what you think happened, then I'm going to need to hear from them. Like, if you didn't talk to them and they didn't tell you this, you can't sit here and say, I'm saying a bunch of stuff, but if they want to argue later that it wasn't true, because that's what they're setting it up as, if they want to argue later that it wasn't true and I misrepresented it, I'm going to, just give a warning of nobody should take me at 100%. At that point, I would have asked him, would you want to confer to make sure it's 100%? Right now, we'll give you a recess because you can't just, once again, assert to the court all of this and then later on be like, oh, what? I misunderstood Mr. Jackson or Mr. Yannetti. And he kept repeating like that Yannetti didn't send it. Yannetti didn't send it. He seems to forget that when another lawyer practices under your license for pro hoc vice, you are responsible for everything that attorney does, whether you, quote, knew about it or not. It's your job to know about it. So if you didn't know about it, you don't get plausible deniability. That is why you sign something saying that you are going to oversee this attorney for pro hoc vice. Like, you can't get out of it. That's the whole point. Like, and that's another thing. I wasn't part of the team. Then nobody cares whether you were part of the team. And then maybe you shouldn't be speaking on this. We should be hearing from Jackson or Yannetti, but we're not going to because they can't word salad their way out of this. There's no plausible deniability for them, and they know it. So they used this idiot like a sacrificial lamb, but they didn't do themselves any favors because the guy's a moron. No offense, but like the guy just argued 4 times against his own argument that he made 30 seconds before that. You didn't give the reciprocal discovery when you knew you had it. It's really that simple. It's not really complicated.
Also, and then you just made the judge look dumb.
Right. Like you got to question the judge and what the judge said. I'm confused here. Now, like, you know, I know some of these people, I don't know how long Alessi's been practicing. I have no idea. Okay. I can tell you this. And everybody knows my story of like how I became like a law nerd and like why. I'll give you like a little clip it if you don't know. When I was 12 years old, I was a witness in a case. And then 2 years later, I was a witness again in a case. But when I was 12 years old and I was a witness in that case, the moment that I sat on that stand and that attorney cross-examined me and tried to ask me the same question 3 times, just worded differently, I immediately knew what he was doing. And I was like insulted. Like, I'm going to give you the same answer no matter how you word it. You know what I'm saying? Like literally, like you can word it no matter what way you want, but it's the same answer because it's the truth. So I knew though in that moment, like that's what I wanted to do. I wanted to be an attorney. Like that is what I wanted to do. Like I went home that day and I wrote, I want to be a lawyer. My mother's like, it was like she's like a whole shares with the apartment next door. It's still there to this day. My mother still lives there and it's still there to this day. I'm gonna have to take a picture of it one day when I'm at my mother's house. But like from that moment on, like I knew that's what I wanted to do. And I became a law nerd. I started pulling law books and studying them and looking at new cases and reading the case law, printing out pages and pages and pages of cases, reading the citations, checking the citations of the cases. Like I went to the courthouse. I sat in on all sorts of different kind of cases, criminal, civil. And then as we know, I was an addict at one point in my life. I was a defendant plenty of times in my life. Like I have now been sober 18 years, but I have extensive experience with the law. I went to college and I had to leave college because my daughter has a rare disease and she was a baby at that point. So I never got to finish school and take the bar, but I've been offered a million times jobs at firms like, Elisa, go back to school. We will take you immediately. I've taken the mock bar exam like a billion times. Like, there are some states, there's only 2 states that you can actually live in the state and just take the bar. You don't actually have to like finish school. If I lived in one of those states, I would already be barred. It's that simple. The offers that I've gotten to work for some of these like law firms have been like, dude, you're better than some of these attorneys that we've had on staff for years. So I don't know how many years Alessi has been practicing, but there's a lot of shit that he needs to refine. One of it is his public speaking. 2 is if you're going to argue something, make sure you then don't argue against your own goddamn point, sir, because that's effing stupid. Like, I've also been a volunteer advocate for almost 18 years. I'm a domestic violence survivor, an abuse survivor. Like, the list goes on and on, as most of you know who know me personally. Like, I've been through the ringer and then some. I've also worked in a prison for the criminally insane as a CO. We didn't get the title of CO because the state, our Governor Baker at the time, fired all the COs. And the private company that I worked for took over. So we took their jobs. So I literally did the exact same job, literal exact same job as a CO. We just didn't get the title of corrections officer, which is like, okay, you don't have to give me the title. I did the exact same job. I did counts, checked on these inmates every 15 minutes. I opened and closed that trap door inside there with all that. Like, we did the exact same job as them. And we had to do back and forth to court too. So like there was plenty of times we had to take some of these people. We had section 12s, you know what I mean? Like, which are the holds. We would get drunk tank people where they would try to hold them on section 12 holds, like, which are, it's a 72-hour psych hold here in Massachusetts. Section 35 is a addiction hold where they would hold you in like a detox locked facility. But I mean, this, like, the guy just spent an hour arguing against his own arguments and not actually getting to the crux of like what they're accused of. You're accused of misrepresenting to the court and not handing over reciprocal discovery. I didn't hear anything in there that said, when we got it, we handed it right over. So we didn't violate. I heard none of that. I heard a bunch of excuses and him trying to get Yannetti off by saying, well, Mr. Yannetti's not part of this email chain. And of course, Mr. Yannetti didn't write this. It doesn't matter. Mr. Yannetti is the sponsoring attorney for Pro Hoc Vice for Jackson. He is responsible, period. It's his job to know what Jackson is doing or isn't doing. And it's not going to help them that Jackson went out the last hearing and lied to the media and said that was never paid. Absolutely not. Nobody was paid. ARCA was never paid. That's insane. Y'all lied again. And you can't claim plausible deniability and say, oh, I didn't know my office paid them. It's your job to know once again. Like, so that's just not the way it works. If every lawyer could just claim like they didn't know, we just have lawyers lying 24/7. Like, that's not how it works. Like,
well, then there wouldn't be a need to have a bar.
Right. Well, that's the thing. The judge will let you get pretty close to the line. Right. But how many times have these guys completely stepped over that line? Quite a few. Yeah, there is a documentary tonight on an investigation discovery. I saw the, what's that thing called? The trailer of it. And I was not really impressed because for me, like, it left a lot to be desired on, like, there's no conspiracy. The conspiracy didn't happen. Right. So for this quote, conspiracy to be peddled in more documentaries, it kind of just completely loses the fact that, like, John's family and friends and witnesses and by extension, and I think people forget a lot of this is kind of what aggravates me sometimes, is I'll see people being like, you know, John's friends and family, and people also seem to forget that it has moved way past just John's friends and family of people who have been harassed, smeared, slandered, lied about, and continue to get harassing phone calls, emails, text messages. Like, you have no idea. I continue to this day to be harassed by these people, to this very day, since 2023. And I'm not the only one. Obviously, Lindsay's constantly harassed. Like, Julie's constantly harassed. Like, there's so many people. It is extended. We're talking over 100 people whose lives have been either very severely altered or permanently altered by a cult of people who want to believe that a conspiracy happened when all of the evidence shows you that it didn't. It just didn't. I'm sorry, it didn't. The federal investigation is over. Literally over. Okay? It's been over since 2024, like I have been telling people since 2024. Like, it's done. They found no corruption. This was a public corruption unit, okay, that investigated. There's no corruption. They found nothing but Proctor's mean text. That's what they found in that whole thing. That is all they found. They cleared the witnesses. They cleared law enforcement from any wrongdoing. Okay. The only person they didn't clear was Karen. You know? Oh yeah, they love to do. They don't care that they affected my income or anybody else's for that matter, and that it hurts people like me. They didn't give a shit. You know? They just didn't. Like, it's. I don't usually complain, but it hurts me to see that people don't sort of realize that it is extended far beyond the friends and family of John and the witnesses. Like, this is extended to anybody who had the balls to speak up and continue to speak up. And it has harmed them irreparably. And this is justice for everyone. And we're going to, you know, at some point, Sewer Turtle's going to have a trial. And, you know, that'll be justice as well for most of us. Like, this isn't okay. It's not okay to disagree with someone online and then go harass them in real life. That's cuckoo banana pants. Like, that's what I used to see in some of my inmates.
Where is he today?
Good question. I didn't see him either. Maybe banned from the courtroom. Hopefully, fingers crossed. Who knows? Did anybody see him? No, I didn't.
No, I believe he was. Yeah, I believe he was. He called into Dirty Tom.
Did he really? Interesting. Well, that's the thing too. Like, I think we're talking about a man who continues to commit crimes to this day. Like, literally. And I've had plenty of his own victims literally, message me and have screenshots of like actual real life blackmail and threats to blackmail and extort. Like, that's a crime. Okay. That's a crime. Like, cyber stalking is also a crime. Like, you can't keep messaging someone or tagging them if they have blocked you and told you this is unwanted contact. If you continue on, they can get an HPO on you, a harassment prevention order. And that goes on your record forever that you were cyber stalking someone. Like, you could be charged with cyber stalking and criminal harassment. Like, you saw him? See, you usually can tell because his giant nose and small arms are in the way. But most of the time, like wherever the
I
camera
had a
goes,
big head and
Yeah.
little arms.
yeah, you can see his like head bobbing towards whichever. If the camera moves left, you're gonna see him try to move left. You know what I'm saying? Like 9 out of 10 times, he doesn't even listen to 99.9% of what is actually said in a hearing because he's too busy trying to figure out where the camera is so it can see him. Like that's literally, I kid you not. Like that's the sad part. Like. It's just sick. Like it's sick behavior. Like I would never go and text and call and email someone and be like, you're such an awful piece of shit. I hate you. I don't agree with you. You're a liar. You're this or you're that. Like imagine Sewer Turtle decided he was going to tell lies about all of you. And then you got a mob of people that just constantly harass you because they believe every word that comes out of his mouth, even when you could pay him to tell the truth. Like that's what life is like for some of us, legitimately. And you would think to yourself, like, wow, there can't be actual people in real life that actually believe someone who's been caught as a liar numerous times, contradicts himself constantly, and like we know like he's a liar. So like, gosh, there can't be people that stupid that just believe everything he says. And remember, anybody he says is bad is usually only bad because they know the criminal behavior he has done, or they have evidence of it, or they're speaking out against it. So then they become bad. They're a target and they're terrible people. They're scammers and they're crazy. And he's set up. He's always set up. Remember that. It's a setup, folks. Everything is a setup. He has never committed a single crime. He's a freaking angel, and it's all some big giant vast political conspiracy. Like, the fact that anybody believes that, like, listen to what I just said, rewind that, and then look yourself in the mirror and go, that sounds cuckoo bananas, because it is. Oh, he doesn't take questions on his channel anymore? Yes, he is a narcissist. That's exactly what he is. Oh yeah, I forgot. Someone told me that he said he's not reading any comments that are less than $5 because it's a waste of his time. I was like disgusted. I was like, what? Like who? First of all, you should be happy for any support you get from anybody. So I don't care if they sent you 50 cents. You would say, thank you. Speaking of which, thank you, Voices, for your $10 donation. I appreciate you.
Oh, you're welcome.
Like,
it wasn't a lot, but it maybe could add to the breadstick pot.
Well, that's the thing, right? It might not seem like a lot, but $10, that will get me some meats, like some deli meats for my kid for school for lunch, and maybe some juice boxes. Like that will, help. Like, so it's like, how dare him say to someone, I'm not going to read these comments or your donations. If it's not $5 or more, don't send it. It's not worth my time. I'm sorry. What? That's crazy. Like that is so disgusting to me. Like, I don't care if it's 50 cents. You say thank you. You appreciate that person because they gave what little they could to help you or to appreciate you. So how dare you tell them that their $2 or $3 or 50 cents isn't worth your time? You're not worth their time. How about that? Like, that's just crazy to me. Like, yeah, I think I have that problem of being like an empath. Some of you guys do too, though. You feel other people's pain, so it like pisses you off when people get hurt.
Yeah.
Yeah.
Shit, I'm excited if I get $1 or $2. Are you kidding me?
Right? You know what I'm saying? Like, it's such a, people don't realize either, like StreamYard went from being $25 a month to almost 50. 80% increase.
That's why I wish Restream would get it together because I'd switch.
Is it shitty? Is that the problem?
Well, sometimes the videos won't play, but then I haven't tried it since I upgraded stuff here.
Yeah.
But I actually like their features better. They have just more, and it's also not as expensive.
Yeah. I mean,
it doesn't cost as much.
To do today's, I was like, what am I going to, fuck, this is going to suck. Like, I haven't paid StreamYard obviously in months. So I went on my StreamYard account and it actually had like a free 1-week trial for like one of the upper levels. And I was like, I'm doing that. And I'll just cancel it after I'm done. Like, and then I'll wait until I get paid.
But Restream still has the free where you don't even have to pay. Just
they have a free version, but like you can't do certain things on it on a StreamYard. Like they took away
StreamYard, the free version is completely bare bones.
Yeah.
Yeah, they did. They changed that.
It's 20 hours a month.
Mm-hmm.
That's like what, 3 hearings? Maybe 2? and then you're at
That's
the
why when
maximum.
I in the beginning I used to bounce back and forth between Restream and StreamYard to get because of StreamYard only having 20 hours.
Right, that's insane. 20 hours? Like, what the hell is that? Like, so that's why I didn't like, you know, I did the like free thing so I could be with you guys today. And like, A, I missed you guys. B, I haven't been here in a while. C, obviously you guys know I've had, you know, with my daughter and her bone marrow thing that we're in the beginning stages of the transplant, like I haven't been available all the time. So like I was available today. The hearing was happening today. It's an important hearing. And I was like, I want to do this hearing. Like, so I'm glad that
My God, these shorts are all either way up and have their butt hangs out or way too long. It's like, don't they sell just regular length shorts for kids anymore? For
no,
girls?
they make half
It's either
everything.
show
Half
your
shirts, half
booty.
shorts.
Oh, you know, I'm not buying them. She's not about to have her booty hanging out of nothing.
It's a fancy bow. I got these bows. They're little bows. I have pink ones, black ones, and white ones. But this shirt's even fancier. It's like open in the back and it's like sort of lacy on the arms, but it's like 52 degrees here today, which is like not normal. And it was like my heat was on like 68 in my house and like it started getting hot. So I opened the windows and I had to take my sweatshirt off. Although I liked my sweatshirt. It says I put the she in shenanigans. Just saying. Like, right? That's another thing. I'm an information person like you guys. I want numbers. I want charts. I want all of the actual raw data that I can look at, especially when it comes to like cases like this. Like, you know, yeah, exactly. You get what you put out. And like, I fully believe this is partly karma coming to haunt Karen Reed in her defense. And I feel like the same will happen with the sewer turtle. Like, you get what you put out. If you put out shitty energy into the universe and lies and deception, like that's what you're gonna get back times 10. Like, literally. I fully 100% believe that. Like, unfortunately, these people have been hiding in shadowy, dark corners, pointing the finger at everyone else along the way so they can keep hiding in those corners. Well, unfortunately, the spotlight's on now and there are no more dark corners to hide in. Like, so we know you're the data guy. That's why I love some of you, because you guys understand me. Like, I am a person who likes information. I like to educate myself more on things that I don't know. I know a lot. I'm definitely full of useless information and useful information, especially when it comes to the law, just because like it's literally ingrained into my brain at this point. So 12, I'm 38. That's how many years? We're talking 26 because I'm going to be 39. So 26 years of law. Like, that's a long time, dude. There's a lot. Like, not even a lot. Like, well, no, of course not. I'm not saying that bad. Dude, listen, I've had so many bad things happen to me. That doesn't mean that I had it happen to me because I did something bad. And there's also things like, you know, abuse and all that kind of stuff. Like, that's stuff that no one deserves ever in life. I don't honestly understand how evil people like that get to walk around on planet Earth just chilling. And then everyone else has to pick up the pieces, you know? Most of you know I have CPTSD. I'm sure some of you have either PTSD or anxiety or so I have what's called complex post-traumatic stress. So it's more than one trauma, right? And post-traumatic stress is one. Complex post-traumatic stress is more than one. So, and I've been fighting that CPTSD since I was 17 years old. So it's something you live every single day of your life, unfortunately. Oh, that's scary. A stalker. I've actually had one of those. Has anybody else had a stalker before? I have.
Once.
Yep. Mine's name was Steve. So I literally put him in my phone as Stalker Steve. Like, that's how scary it was.
I had Stalker Bob.
Stalker Bob. Stalker Bob. Like, Stalker Bob. That's funny.
Everywhere I went, he was sure to go.
So weird, though. Like, you'd have to think, like, you have to have some serious issues to be following someone around all the time. Like, dude, get a clue. Oh, something's happening.
Get a hobby.
Oh, here comes the judge. All right.
I wish she'd just give us her decision already.
I know.
Proceed back to the podium, Your Honor. Would
Please.
you like to remain seated?
Oh God, he's not going to
You
shut
can
the F
go
up.
back.
God help us all, everyone.
May I continue, Your Honor?
Please.
Thank you. So, Your Honor, to blend and quickly summarize what we've gone through I'm using the table of contents of the notebook.
Oh God.
We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We talked about June 10th and statements of counsel. We talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to
He doesn't know this?
the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry
Speculation.
forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them and we'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important because
Why?
my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly.
Oh, please.
So now we go to page 54. And this is going to be, in some points, a line by line because the words matter. Line 5, and this is again is Attorney Brennan.
Mm-hmm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity.
You're just going to yell out words.
Next statement,
phrases.
that there's some bias or favoritism
Bias
that the expert
and
might have
favoritism
towards one side for whatever reason. I don't know what's meant by favoritism,
Here we go.
but having worked with experts almost every week, you call an expert to testify.
Knowing you're
I
going
don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that expert is biased. But this expert was not engendered by the defense.
By the defense.
It was engendered by the U.S. Attorney's Office and their federal investigation. Next on line 12.
It's a stupid
So
strategy.
that if that information is not disclosed, really?
Really?
It was on February 12th
Oh.
of 2025.
Oh,
Now I'm
my
going to get to this because, and this is not speculation, this is fact.
You've had it
The
since
entire
last year,
buildup of
bruh.
February 18th
Dumbass.
was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was
Can't answer
February
anything, can you?
12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery.
Yeah,
et cetera, et
patronize her
cetera.
some more, please.
So-
By all
so-
means, Alessi.
I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because
The
it's
judge is like,
really important.
sure.
When there are claims made that the defense has not turned over something and there are words used like
Word salad.
ambush and duping,
Duping,
it's
yeah. That's
important to
what happened.
understand and get behind those verbs as to what the facts are.
No.
So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have.
Adequate
The Commonwealth
discovery.
had
Let's keep
for
yelling
5
phrases
days
and words, you idiot.
the very discovery that was being discussed that the Commonwealth didn't have.
Aha!
If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that.
Do you?
I agree completely
You
with
had it
that.
in July. You didn't hand over until now.
And we complied
No, you
on
didn't.
the 12th.
February 12th, after
And
paying
it's
them.
for this trial
July?
that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial.
Maybe you can borrow some.
I've tried
Mr. Burns back there.
unsuccessfully sometimes to talk about the baseline with the Daubert issues. And Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken.
That's
Now,
not.
I wasn't at the last trial, but I've read the transcripts. That's an
Patronizing the
important point,
judge.
Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new.
Yeah, except
So
he
I
knows what he's
appreciated the
doing.
comments he had made before.
And you don't,
But his
clearly.
comment here is I've read the transcripts and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break.
Blah, blah, blah.
And so we then turn to
Reading more words
a
loudly.
continuation of the buildup. which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with the defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about.
It doesn't matter what material.
I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back.
Oh, for fuck's sake.
Great ideas can come from anywhere.
Sorry, guys.
With Wix, you don't.
Not like we're missing much.
It's not a statement that he got them from the defense, which is a fact. And that we got new materials, but a qualifier, just some.
Just some.
But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery.
A bobblehead, baby.
We had given full discovery. We had given it.
That's what it is.
Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds? When he really got it from the defense. There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses.
We know what Mr. Brennan says.
he
We don't
goes
need you
on.
to read it over again. This is fucking, I don't know why the judge hasn't stopped him. Like, we know.
But if
what
we
he
look
said.
back earlier in the
This is great.
relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email.
Yep.
But the clear import of the point here is that the Commonwealth is saying right here
Yes, it
that
is.
this is when I discovered these emails. This is how I
You
got it,
corrected the
not from the
record.
defense, but the federal government. And we know now that that's incorrect.
It's
Then we
irrelevant
proceed
where
down
he
to
found them.
page 57. The Commonwealth, as I understand it,
Yes, Parson.
was not aware
Yes.
of any promise, rewards, or inducements or payment.
And they weren't.
They relied on a reciprocal discovery order of this court for that information.
He really is freak.
That's a misdirection.
No, it's stop it. He corrected
That's
the
a
record.
misdirection.
It's not, but okay.
There was no promise, rewards, or inducements. or
You
payments
paid them.
before all of those documents that the Commonwealth is referring to here.
There was a bill, so you knew you were going to have to pay
That
them,
didn't come until the invoice came in July.
and you still paid them.
And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it.
Oh, but you never told the court that. That's the no-no, dumbass.
So next, on page 57, line
If you
11.
really think you weren't going to
He
have to pay
reads-
witnesses, expert witnesses? Get the fuck out of here. Nobody thinks you thought that.
Response. Hi, Alan. subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression,
24.
Clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates.
Shut him up,
But
bro.
this is a very interesting paragraph. Hi, Ellen. Subsequent to our conversation on Wednesday,
Oh, no, Anna.
the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1.
Oh my God, dude. The judge
my
needs to
notebook.
like put a cork in this nonsense.
Because this was a purported quote
Just saying the same things over and over.
of the March 22nd email.
It was.
He's trying to confuse her.
Yeah. She has it all.
Really not close to what the email says.
What? Yes, it is. We have them. The fuck you mean? No, he has not answered a single question directly. He's just danced around things and told the judge he can't 100% know. So then why are you talking then? He's just like flipping things open and close.
It's not totally incorrect. But here's what I'm going to do, Your Honor.
Not
I'm
totally
going to
incorrect now.
assume that the
It's not even
court
close, he said.
reporter
But then it's not.
transcription was not accurate, and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt.
Oh,
I
please.
can tell you that I've had my statements in court not completely correctly transcribed by a
Except
court
we
reporter.
have it on
And
video.
unfortunately, sometimes
dumbass.
it's been on some key things. I don't think this is key at all, but I just note it.
On video.
But it says, Mr. Brennan goes on, now it's the opinion that troubles me.
Yeah, still not to assume.
It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCA experts.
And
Saturday, June 22nd, Daniel Wolf
Saturday
wrote,
evening.
Alan, I spent some time this morning putting together a brief outline of my qualifications.
not business hours.
Blah, blah, and this is just a repeat of what we have already heard.
So
Here now
read it.
comes the important points. Page 58.
Oh, you didn't get to those yet?
Line 2.
Blame the court reporter now.
Now,
Yep. it's the court
this
reporter's
isn't
fault.
information provided by the defense in reciprocal discovery.
No, it wasn't.
Oh my. This isn't information. She's talking about all these emails.
Yeah, you
This
didn't
isn't
provide them.
information provided by defense
Till
in
now,
reciprocal discovery.
almost a year
This
later.
is information provided by the federal government after numerous requests.
Thank you.
Jury
We heard you.
requests. And an insistence, the best I can to get as much information as I can.
Oh my
It's
God.
incorrect statement number 2, and it's an important one.
Oh God. This is painful.
Down
Listen
below,
to him.
unfortunately, it gets even more incorrect.
Oh my God.
Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant.
Even if they did, it doesn't matter.
So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline.
Not what he said
An
at all.
outline of the question and answers for direct
He said he didn't
examination.
know who provided the outline. Someone did.
Mine.
I watched it.
That's not a fact, but that if that were true, that would be very bad.
So what I'm going to do, I had no
Shut
idea
up.
it's this late. So it's
Yeah.
1:00. We're going
Shut
to
up.
break for lunch. We'll stop back up at 2.
Okay.
Come on, dude.
Do you think I
can
have
wrap it up.
no idea how much longer you're going to be, Mr. Alessi? Do you have an idea? And I'm not rushing you.
Please
Do you
rush
have an
him.
idea? Because we do
Shut the
have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
Like, come on, man.
I'm going to answer your question. I think I
I'm gonna-
can conclude in 45 minutes.
What?
Because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a
That's
time
my
frame.
best answer, and I will say this, Your Honor.
Oh
I
my
share your
God.
interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share.
Then shut the fuck
goal.
up already.
Okay, so we'll see everybody.
Oh my God, I thought you were Bev saying that.
No,
are muted.
just me.
Oh my God. Now we're breaking again.
Just me.
We have an
Like,
hour
no.
off, you guys. An hour.
He said fucking in 45 minutes. He needs another 45 minutes to say nothing? Legitimately nothing. He needs 45 effing minutes to literally say nothing.
Yeah.
Like, this
It's
dude
insane.
argued for the last hour that they provided it February 13th or February 11th or February blah, blah, blah. That was almost a year after you had it. That is not giving reciprocal discovery when you're fucking supposed to, dude. You duped the court. The judge is not an effing idiot. And you keep insulting her intelligence by like being like, whoa, Your Honor said. I think she knows what she said. Like, then he just went back with the email. Well, that's not at all what it said. But then he flips to it, right? Reads it and goes, well, it's just off a little, basically. Like, that's like, didn't you just say that's not at all what it said? Now it's just a little. Now it's going to give the benefit of the doubt. We all know what he said. Does he seem to forget that it's all on video? We have every word that was said. Every word. And I remember last week when him saying, I don't know who wrote the outline, but there are notes in the margins. So one of them did. Like, he had no idea whether it was the defense or Dr. Wolf, but someone wrote the outline and then someone wrote in the margins. Also, you had a Saturday email. That's not business hours. That's like not normal. Like when it comes to experts, like here in Mass, like you wouldn't be sending Saturday morning emails back and forth with an expert. And then he references a phone conversation. Like, okay, so they had a phone conversation before they had this email, okay? So God knows what was said in that phone conversation, except none of that was given to the Commonwealth in reciprocal until this point. You hit it. It's that simple. You had no choice but to hand certain things over. I think they knew the feds were like going to make the announcement. And I think they knew if they didn't give it, that it was going to be given by the feds to the DA's office anyway. So giving it now doesn't save you, dude, just because you gave it now. Like, that's not how it works. You made misrepresentations to the court, period. Like, you prepped with them. There was an order. I remember Alessi saying in the beginning, oh, well, the Commonwealth didn't reach out to ARCA. They couldn't. There was a federal protective order. Duh. Like, it's part of the problem is you guys broke it more than once. Like,
Hey,
to me, it's insane.
So while we've got this break, I think I need to go and run and grab lunch and run to the market real quick.
Go for it.
I'll be here. Just because otherwise, by the time this all gets done, I'll be hangry.
Mm-hmm. We don't want you hangry. We don't want anybody hangry.
I don't want to be angry. So I'm going to go run and grab my stuff and then I'll come back. How's that? But I'll be listening.
Good. We'll be here.
All right. We'll see you in a bit. Bye, Kathy.
I mean, this is just insane to me. Absolutely nutty to me.
Bye, Voices. Sorry. I was trying to get to the phone.
Dude, he spent 11 o'clock or 1 o'clock? That's how long we've spent talking about nothing? Like, nothing. Like, absolutely nothing. Like, that's insanity for me. That was just the most waste of 2 hours I've ever had in my entire life. Like, come on, man. Like, this be cray-cray. Like, I'm not understanding what exactly the F and F is happening here. Like, he did not need 3 hours to be like, Your Honor, we deny all of this. We say that we paid this bill of $24,000, even though Jackson told the media that it was not paid, which was a lie. As a matter of fact, you know what we should check? we should check Court TV to see if we have any commentary and see what they say, because I know Julie Grant was on earlier. That is my friend. I love her. If you guys don't follow her on Twitter, you should. But I know they were covering some of this morning. So I wonder if they have any commentary on it right now. What's this? 2 hours ago. Maybe this is it. We'll check. I'll look at it. I gotta wait until the stupid thing ends. But I really want the judge, like, we're gonna have to hear from Brennan at some point, right? Like, and I would like to hear from him before the day is over about like arguing. Like, I mean, I don't even know if the judge will. She has all the evidence. That's why she didn't even need to hear from them, really, because it's like, regardless of what they say, she has all of the evidence right there in front of her. Like, she doesn't really need them to say much. Like, that's why she said, well, I don't even, really need to hear from you. So it's like, yeah, exactly. Like, he was, crossing the street. Like, I'm sorry, what now? Like, we're talking about whether or not there was a misrepresentation to the court and a rule. And you broke the protective order. So that's another thing. Like, you were not to have certain contact with them, like, of ARCA. And the fact alone, though, that the federal government didn't even give them all of the information. They said, we're not giving you any more information. We're giving you these things, and you are to make a conclusion based on these things, which didn't include the text stream data that those people are experts in, right? Like, why wouldn't you give them the data that they're experts in to make a conclusion? I mean, didn't work out so well for them anyway. The federal government, as we know, has been done with their investigation into this since 2024. They found absolutely nothing but mean Proctor text. And I said this a year ago. Me and Bree told you guys numerous times this a year ago, as she tweeted yesterday. Love that tweet, by the way, Bree. We told you it was over, and that's all they found, but no one listened. So now that mainstream media is actually putting it out there, which a whole day after we did, like, not to need to remember, like, they found nothing. There's no corruption. There was no cover up. And I've been seeing the cult say things like, well, Karen's cleared then. No, geniuses. She is not cleared then. It's not what the investigation was about. It wasn't to clear her. Okay. The public corruption unit of the feds investigated it, in which they found none. No cover up, no nothing. And they had more information than the state had. Things like where each person was. And I don't just mean like GPS coordinations. I literally mean like they have the actual data that like the state didn't have. So it's like they ruled out all of the witnesses, all of the law enforcement officers. There was no cover up, no conspiracy, none, zero. It ended with no indictments, no charges, no nothing. These people were cleared. And then they got a phone call to say they were cleared. I don't understand how like that's confusing to the cult in any way. Because I've seen things such as like, oh, well, Karen must be cleared then. No, she's not, or she wouldn't be going into a second trial, genius. Also, if she was cleared, the feds would have stopped this. Hello. The whole point of it, like them being called to being told it was over, to be told they were cleared. Like, it's been over. They found nothing. The feds are not coming. They're not coming to arrest witnesses and law enforcement officers. It's not happening. Like, I don't like, yes, exactly, Bree. When someone presents their conclusions to the court, it more than implies said investigation is wrapped. Otherwise, they'd be preliminary findings, not conclusions. Yes, exactly. Exactly. For me, it's like, I don't know. And me and you talked about this when we streamed the trial, like how ARCA could have gotten up there with a straight face, knowing after they were told they didn't have all the data, things like text stream, what the weather was like, whether it was dark, whether there was ice, like all of those things are important for, quote, science and physics. Like, people scream science and physics, but you don't seem to know that if the wind changes direction or how fast a car is going makes a difference. Like, someone else said something like, how could a soft body break a taillight? First of all, a body is not, quote, soft when there's a car backing up at it at almost 24 miles per hour. Number one. Number two, like, I would give you a metaphor, right? It's like hail. You can have hail the size of a quarter, not very big, the size of a quarter, smash glass and dent your car because it's falling from the sky at a certain speed. Like, if I throw it at you from 2 feet away, it's not even going to hurt. Like, but if it's coming pelting from the sky, it could break the skin. It can dent your car. It can smash a window. Like, it's not really hard it's not rocket science. Apparently for some people it is, though. As we know, for some people it is rocket science. I feel like we need to get rocket scientists on here, like as guests. Like, hello, rockets. Actually, I have a friend who's a rocket scientist. I should ask her. Like, hey, can you rocket science over some physics for these people to understand? Because in order to have the correct science and physics, you need all of the information possible to then make a determination. If you're missing information, it could affect said determination. Like, it's not hard to understand that fact. Well, for the cult, it's hard to understand. For normal people with brains, it's not really hard to understand. Like,
I just hope we're not going, she's not going through all this just to turn around and give them a little talking to and not have no consequences. Do you think it'll affect anything?
I don't think she can do that at this point because she's given them so much leeway when it comes to the defense. She's let them toe that line. She's let them cross that line, and she has not yet given them a sanction for it. And I think there are a couple instances where they absolutely should have had a good public talking to. This is far beyond that line. If she doesn't do something drastic, then I think it's an open door for any other attorney that comes into her court to act this way and be like, well, we can get away with it with this judge. And not only that, but it makes her look soft to her colleagues. People already have criticized how soft she has been on the defense. Mm-hmm. So, like, this isn't going to do her any favors in her career as a judge. Most judges want to keep their, career, that they're not just pushovers. Like, they want that look that they're not just going to let judges come in and, attorneys come in and steamroll them in their own courtroom. And like, I don't think Alessi's, his tactic of patronizing the judge and insulting her intelligence about what she said and then using definitions of the words that she used is going to help him. As a matter of fact, if you came into my courtroom and you tried to insult my intelligence and you tried to patronize me, I would throw the effing book at you, especially since you just tried to talk your way out of it. And while you were talking your way out of it, you literally argued against yourself like numerous times. He just argued against his own argument like 4 times.
Yeah, it was really bad.
It was hard to listen to, bro. Like, literally, I'm
not done.
I mean, that's the thing, though, isn't it? I mean, if you're not a dumb attorney, I don't know why you get involved with this case because it makes you look dumb. Like, it literally makes you look stupid. Like, take Betterow, for example. First of all, he knows damn well he can't represent Karen Reed and Aiden. He can't. It's a conflict. You cannot do it. Like, you can't have one person's interest over the other. How do you pick? You can't pick. That's not how, you don't get to pick. That's why you can't take a case that's a conflict. Like, that's, But we're talking about this guy who claims he's so smart. He's such a big, bad attorney from New York. But he simply didn't even know the person's case that he's wanting to take didn't need to prove intent in the state of Massachusetts, and then proceeded to argue with me on social media about it. It doesn't need intent in the state of Massachusetts, bud. The fact that you don't know that, didn't take 10 seconds to even check or look it up before you want to argue with someone on social media, shows that you're not smart. If you were, you wouldn't make that mistake. Maybe brush up on your Massachusetts law, Betterow, or maybe don't write, quote, letters. And there's a reason why he didn't put it in emotion, because you can't put lies, knowing lies or speculation in emotion. So he wrote these, quote, Betterow letters that are just filled with BS. I know for a fact that 99.9999% of it is all bull-faced lies. And that's why it's not in emotion, because as an attorney, you're giving it to the court, like, and saying, like, this is true to my knowledge. Like, you can't put it Betterow letters in as that, because a lot of it can be debunked easily. So, like, I'm sorry, but that doesn't seem like someone who's very, quote, smart to me. That doesn't scream smart.
It's insane.
Conflict. Like, the fact that he even tried to get into the Karen Reed case, you're already representing Aiden. Like, it just speaks volumes. The dude has been looking for attention for quite some time. Like if you're a trial attorney, like, and you're on YouTube, like, yeah, maybe you'd have time maybe once a week for an hour. This dude's on constant. How do you have time as a trial attorney? If you're not looking to be famous and have clout, you wouldn't have signed on to the Karen Reed case. You certainly wouldn't be signing on pro bono, and you certainly would know it's a conflict. It's common sense. He's not a complete idiot. He has to know it's a conflict. Like, so it's like, why do it? Why do it? Just to get people talking about it. That's why. Like, and why are people still donating to Karen? She said and it was her words of her lawyers, like, they're not being paid. They don't need money. So what is the money for? What's it for? Why are people giving Karen money if she doesn't need it? To stay in the Omni for another 150 days? To go to Smith and Walensky every night for dinner? For what? Exactly. Because to me, you have a wealthy defendant asking people who get Social Security, disability, work jobs, and they work hard for their money to forego a large pizza and buy a small pizza, or forego their coffee to give a murder defendant that money so that, for what? So that she can what? For what? They're not being, her attorneys aren't being paid. She absolutely does not need to stay in a high-class hotel. That's for sure. That could be an expenditure that she could have spent over $100,000 on, that she could have cut out. No need. She could have stayed in her own house before it was sold, or with her parents, or I don't know, a cheaper hotel, not a suite at the Omni. Like, I think your money is better spent giving it to people that you can actually appreciate, that have some damn integrity, number one. And number two, that actually might need it, instead of someone who clearly does not. Like, clearly that family is of privilege and wealth. Like, that there's no mistaking that. But to keep giving her money for I don't even know what, if your lawyers don't need to be paid, then it's not a defense fund anymore, is it? So what are you using the money for? And that has yet to be told to anyone, because as far as everyone knew, it was $5 million, and that she was in debt $5 million that she had to pay them. And then we find out with this recent interview that it would have been $5 million if she had to pay it. It would have been. Well, that's not what was told to everyone. It wasn't, well, it would be $5 million. It was told $5 million was the debt. Those are two very different things. Like, my friend just made a very valid point. She just texted me and she said, what if Alessi is trying to just keep talking so he doesn't give Hank a chance to respond or give the announcement that the federal investigation is over? Like, what if that's like the play here, to stop Hank from like talking? I don't think the judge will allow that. I think she'll allow him even like 5 minutes if he has to. And Hank's very savvy. He'll get it in there, you know, like, oh, I think they have a hot mic. They have a hot mic. Hold on. I think they might have a hot mic. Hold on. The court people. They do have a hot mic. Ooh, let's see if we can catch something. Freeze. Oh, they shut it off. Damn it. I wanted to hear a hot mic moment. That would have been great. Damn it. They shut it off. Well, it was worth a friggin' shot, right? Right. Dude, why do you keep what is happening right here? Like, what is this? Like, what are you putting your head in? Did they end it? No, it still says live. I'm so confused. I mean, it might be the play. Like, well, that's the thing. If you're going to say that it is $5 million and I'm in debt $5 million is very different than like, it would be $5 million if I had to pay. This one is sour apple. I do have a fucking fab somewhere, but I think it's done. And this one is, oh my God, blow pop. And this one is cherry bomb, but these ones are on like 0. This one's on like 5%. I got to get a new one today. I don't like orange. I'm not an orange person. I do like the regular cherry bomb, Sagittarius cherry bomb. No, see, look, the hot mic did again. That's so weird. He's like telling people, "Oh, I'm just trying to get it up to the ceiling." Like, no, give us back Fanny. Like, you know what? I know you're new here, Spitfire, but I used to stream multiple times a week, especially at night. I have a daughter who's sick, who needs a bone marrow transplant, and so we've been dealing with that for some months now. So that's been obviously priority. But I thought this was an important hearing to cover, and it is an important hearing to cover. I just wish we didn't have to sit here and talk mostly about Alessi's nonsense, because like I'm a law nerd, dude. Like, and especially in Massachusetts, I know these laws like the back of my hand. I know the procedure like the back of my hand, and like I love breaking it down for people, like if they have questions about it in like a layman's terms, so they can understand it better. And obviously, I've been covering. Most of you know I've been covering this case since 2023. So, yeah, I know I have it on. It's on. So, but I mean, I'm hoping to be able to stream more. But again, I have to find a different platform than StreamYard. StreamYard's almost $50 a month now. It used to be 25, and I can't afford that because yes, I'm a poor person. Like, I'm a poor person, so I cannot afford $50 a month. That's insane. So I'm gonna have to find a different platform that's a little less money. But then I have to learn that whole platform because I'm used to StreamYard, of course. Like I know, mostly everything on how to do everything on StreamYard. I actually like StreamYard. So it's a shame that they increased their prices by like 80% because that's insane. There's no reason for that at all. Like, so for instance, I got 2 $20 donations and a $10. So that's $50 that I made today doing my stream. I would have to spend that entire thing on a month of StreamYard, right? And then another like 15 on Canva to do my intro and my outro without getting a copyright strike. So that's already, I'd have to make, I'm a small channel. So it's like, you know what I'm saying? Like if you have to even out what your expenses are versus what you might make, it doesn't seem like StreamYard's worth it anymore. So. Oh, God bless your grandson. My daughter hasn't had cancer, but she has a rare disease called STAT3 gain of function, and less than 200 people on Earth have it. And a lot of the things that she has going wrong medically, like she has scleroderma, she was just diagnosed with, which is like it hardens the inside of your organs, and it lowers your life expectancy if it's progressive to 3 to 5 years. My daughter was born with her disease. She's 20, but she was born with her disease. And she has done chemo numerous times for her disease, not for cancer, but it's the same drug. It's the same exact drug. So she gets all the same side effects as, and bone marrow will have to go through some of the same things. Chemo radiation is often given with bone marrow. Sometimes I'm not really sure what. I don't think they obviously would not need radiation, but most of the time she still would have to do the chemo. So, but again, we're still in the beginning stages of the bone marrow. We're still looking for a match. So that's, we're still waiting to see if any of us are a match. So I hope they just don't take forever for lunch, although we know they're going to. Like, dude, I did the same thing. I stopped with my vape, but I literally was like, I was trying to cut down on my smoking, and like I cut down to like 3 or 4 a day. And then I just woke up one day and stopped. I was like, yeah, no, I'm not feeling it. And then I got sick and had the flu for like 2 weeks. And obviously you don't want to smoke when you have the flu, but this came in handy because it actually tasted good. And then I just never picked up another cigarette again, literally. Like, so I kind of did the same thing. So I know what you mean. I know exactly what you mean. But God bless your grandson. Cancer is tough. I lost my grandfather to cancer, pancreatic cancer. Yeah, I miss Heels too. I miss her. We started this together, so that's why I have to see it through. This case to the very end. She would have, so I'm gonna. Hold on. Boop, boop, boop. There you are. Thank you. I appreciate it. Prayers are always welcome.
Oh, Kathy, I got the kids their Easter presents.
Already?
I
don't
just
even know.
found
I'm
them
gonna
at
get
the Easter store.
You
Look at this.
spoil your niece and nephew.
I just found these at the grocery store. I'm so excited about them to get them sent off.
Oh Lord. What? Oh my gosh.
It's a great big dinosaur, and it's got like a hammer, and you like knock out the.
Oh, you smash it? Little smashers?
Yeah.
Oh,
Egg smashers. Yeah, my daughter actually likes
that's
those.
cute.
And then I got
You'll get a kick out of that.
and then I got the girl 2 little they're unicorns. They're
Oh, yeah, I know what
unicorn-
those are.
Unicorn
Aw.
squad unicorn little things. So
My
I
Oh,
got
they're
them.
LOLs. Oh my Lord. She's an LOL fanatic.
Yep. LOL 5 surprise. It's a 5 surprise unicorn, but
Mhm.
yep. I've bought
So-
those. They're like $5 each, $6 some of them, but my kid likes them too.
I just bought them at the grocery store.
He's
and they
been
were,
collecting LOLs for years.
those little round things were 2 for $5.
Oh, it's not bad.
Wow.
And the big egg was like $7. It was like $6.99.
Yeah, usually they're like
Oh.
$5 a piece for one of those.
Yeah, that you got them 2
Yeah.
for $5. LOL.
Yeah, they're good.
Holy
Yeah,
cow.
This wasn't even $10. This was $10 or $13 in here.
That's not bad. Usually that would be like around
Yeah.
a $20. Yeah.
Yeah.
No,
Because
I
I've been buying her LOLs now since she was 4 years old and she's 9.
Yeah, I know.
can't
Mine's
afford-
7, which I have 5
Listen,
surprise.
I only get the kids things when I see little things here and there. And
Yeah.
they're at the little market that I go to. And if they're over $10, I really can't afford them. But
I know.
I have gotten Kathy's kids something for every holiday.
Oh.
So
Yeah. And
there's been
voices.
something- Yep. There's been something for Christmas. There's been something for Valentine's.
I love that.
So it gives me somebody to buy for because I don't have any littles anymore. All ours are teenagers, and they
I
would just
know.
rather like the cash.
Well, that's the thing, right? Like I
Cash,
obviously
and
there's
they want to go.
2 older ones and 1 little one. So for me, it's still fun for my 7-year-old. But like, don't alert parents. You know what I usually do is I use baby powder and I make a stencil out of like cardboard of bunny prints, and I make bunny prints from the front door to wherever I put her basket. So she thinks the bunny came.
Aw.
I saw something that made me giggle so
My
hard.
baby's going to be 7 in Thursday.
Oh, don't they grow so quick?
Yeah, he informed me he's an old man now.
I know. I got a couple really nice gifts for Christmas this year, which I don't normally get from a really I appreciated it. That's for sure. I didn't share a lot of my personal stuff with everyone, but I did appreciate the people that thought about me because it's been a tough last 6 months. That's for sure.
I saw the cutest thing to do with your kids on Easter.
Ooh, what is it?
You plant jelly beans at night. You take the jelly beans and push them into the grass. And the next morning, when they come out, you replace the jelly beans with lollipops.
That's kind of cool.
Yeah,
So-
that is.
You could do that, like the how many licks the Tootsie Roll lollipop.
Yeah,
So you
I just
plant
bought
jelly beans.
box like 2 weeks ago of 200 eggs because I have like when I mean enormous, I don't even mean big. I mean like an enormous like fenced in yard. And the kids are going to have a blast doing like the Easter egg hunt this year. And like, I didn't want to because sometimes we put like change in some of them. Sometimes we put dollar bills in some of them will put like little toys and some of them would put candy. So like this year, I usually do about 100 eggs, but this year I bought 200 eggs because it came in a box and it was like just a whole pack of 200 with the 1 golden egg. So I was like, I'm going all because I want to be able to spread them across the entire yard instead of only going to one portion of the yard because the yard's too big to like do just 100 eggs. So they're gonna blast.
Yeah, we have these friends of ours. They do that on Easter morning. They'll go out there. They'll be out there at 5, 6 o'clock hiding eggs all over the yard.
Yep.
And when the kids get up, they open up the door. There they are.
I do what my grandmother did for us, which is I do the outdoor one, but I also do indoor ones for when they open their baskets. So there's still eggs in the house and I just put their names on them. Like my mother used to do. She used to put like our initials or like a first letter of our name so that it was even. Some people just let the kids do a free-for-all where it's like however many eggs you get. But if I do it that way, then the bigger kids are going to have more eggs than the littler kids. And then, so I just make sure that there's like exactly, they're split evenly.
Yeah, I just let them go for usually it usually is. I pay attention to that when they're finding, but Dallas is actually usually quicker than his sister.
Yeah, see what I'm saying? Like one
But then
kid's
he
gonna be
gives
the
them to
quickest.
her, so I do pay attention to that. They do pretty good. They're
One time, when we went trick-or-treating, I went to a door and this lady came out with a bowl for the kids of candy and then a bowl of nips for the adults. And then she had like in the middle, she had things like Red Bull and water for people who don't drink. So it was like in a bowl for the kids and a bowl for the adults. I was like, adult trick-or-treating? I love this.
Oh, I love to go up to the house and get one of them little shot bottles of ice cold Fireball.
Yeah, that's what they were doing. And I was like, I love this. This is so funny. I love that. Adult trick-or-treating. I freaking love it.
It's so hot down here, usually for trick-or-treating. It's nice to have a cool off.
I wish. It always cold. Although the last couple of years, it's been between 60 and 70, which is a shock because it's normally not. So the kids have had a good run of it being like decently warm the last couple of years. But usually it's cold. And so they got to wear jackets over there and under their costumes because they're not made to be warm, like I always thought about it, though.
Where I come from, we design Halloween costumes around snowsuits.
I know, right? Such a good idea, though. Like I remember as a kid, people being real creative with like making like their own like headless costumes and all sorts of stuff that my neighbors used to do. Like I still bring my kids back to the neighborhood I grew up in every year. So we see all the neighbors that I grew up with because they all still live there. And like they always give like full-size candy bars and like every year they're like one for mom, one for dad, one for the kid. Like, so I always leave with candy anyway, like they know what my favorites are and they always have them. So and I'm not a candy drinker. I don't usually eat candy. Like I don't know. Recently I've really had a Reese's mini thing, like not the regular Reese's, but like the mini ones you have to like unwrap, not the like mini ones, but like the normal miniature ones that you have to like individually unwrap. For some reason, I don't know why, lately I have wanted those. And I don't normally like snack. I don't snack like that. I don't eat like candy.
Those are the only Reese's I don't like.
The little mini ones. It's the only ones. Like I tried the really little mini ones. I don't like those ones.
They taste funky.
You think they do? I think it's too much peanut butter for me in the big ones. I think that's my problem. Is I just want that little bit of peanut butter.
I like the Reese's eggs, or the
that's too much peanut butter
or the.
Oh my God, that's Frank's favorite. Oh my God, those Reese's peanut butter eggs. Oh, look out!
Yeah, see, that's too much peanut butter for me. I know. Yeah. Although I do love breadsticks, I'm not gonna lie. I love breadsticks.
Oh yeah.
Who doesn't like breadsticks?
I'm having chicken strips and tater tots.
I haven't decided what I'm cooking. Oh my gosh, it's 1:30 and I haven't even thought about cooking dinner yet.
I took something out this morning at one of the last meats I got. I bought one of those things at 3 pounds of ground beef. And what I do is I cut up, a pound before I put it away. And then I put it in Ziplocs, like, a pound here, a pound here, a pound here. Cause I only cook usually a pound at a time. And, I took my last one out this morning. So I think I'm going to make, sloppy joes with it. Haven't had sloppy joes in a while.
That's not a bad idea. And it's
right.
Yeah.
And how do you make your sloppy joes? Because if you use a pound of ground beef, it's a cup of ketchup, a quarter cup of mustard, and a quarter cup of brown sugar.
Ooh, I've not made them that way. I use them tomato paste usually.
Nope, just use a cup of ketchup, half a cup or quarter cup of mustard, quarter cup of brown sugar. It'll make it. And while you're frying your ground beef, chop up some pickles and put those in there and pour a little pickle juice in it while you're doing it. And I promise you, you'll never make sloppy joes any other way.
Oh, that sounds so good. My dad, funny you say mustard, because my dad's like secret ingredient to like a lot of marinades and stuff was to add mustard to it. Literally. Like he'd get like a barbecue marinade and just add mustard like into the marinade and then mix it in. And we'd always be like, Dad, what did you put in the marinade? Not telling you. I'm not telling you. Finally, one day I caught him doing it and I was like, that's the secret. Like, the secret was the mustard the entire time. Like, They didn't have Reese's overseas. Is that real life?
What?
Overseas, they didn't have Reese's? Is that like real life thing? God damn. Has anybody ever tried the overseas different kinds of candies? I see they have like
Yeah, when my hubby was overseas and my brother, yeah, they would, and my niece, yeah, they would bring stuff or send stuff.
That would be so cool. I feel like I would love to get a box of like overseas kinds of like chips and candy, and like even if I didn't like it, you got to try it. Like,
yeah.
Although I don't like
my
spicy.
son went to Germany to play when he was in college. They went to Germany to play a team over there, a college team over there. So he brought some stuff home from Germany. Yeah, they can have it.
I had a friend who was stationed in Germany. He was in
my brother was there
National
for about
Guard. Yeah.
12 years.
Yeah, he did his last deployment in Germany. He was in the National
My
Guard.
brother, he spent a lot of time in Germany.
I'm like, dude, it's, my bucket list. I honestly, if I ever hit the lottery, I'm buying a giant Class A, and I want to just travel in that Class A.
Yeah.
I can't do avocado. I don't know if it's the texture, the flavor, maybe the texture. I don't know, but I don't like avocado. I don't like guacamole. I don't like avocado. I cannot do it.
Yeah, I don't do avocados either. I don't like guacamole.
Same. I don't like avocados either.
Usually people are like, you don't like avocado? You don't like no, I don't. It's gross. I'm sorry.
Yeah, I don't.
Like I can't.
Listen, I'm not 100% sure if I even like sour cream or not.
I like sour cream. If you ever eat sour cream, you get Doritos. Doritos and sour cream is delicious. Or Cheez-Its and sour cream. It's delicious. I'm sorry. I'm sorry. She disowned us because we don't do avocado.
Oh, that's okay. That just means that there's no fight for the avocados when Bree's hanging out with us.
Right. You guys can have more avocados to yourselves, right? Like, although I think my sisters tried to get me to try avocado toast like a million times. Like, pineapple on pizza should be banned.
Okay, now we're going to fight.
It should be.
By the Geneva Convention.
Whatever happened to just a regular pizza?
Right.
Oh, pineapple.
Now people be putting all kind of crap on it. It's like,
be a bacon and sausage pizza is delicious.
Yeah, I'll do that, but pineapple? No.
Yeah, throw the pineapple on with the bacon and sausage. Oh my God, it's perfect.
I have heard that. I have heard people say do it with bacon with the pineapple.
I do pineapple and pepperoni. That's my favorite.
I love pepperoni. Love it.
And so
we bring some of these controversies here on my channel, Anna, especially when we've talked about everything that happened in this stupid hearing already. So we got to move on to other things until it comes back, because there was really not much to say about Leslie fucking spending 3 hours saying nothing.
Using a lot of words.
But saying nothing. Did I not say that would happen?
Lots and lots of words.
He literally did. He said 1 million words and actually said nothing. Like,
it was like, jeez, why is the judge even allowing so much fluff?
Do you guys realize that it's almost been a year since Heels passed?
Yeah. I was thinking about that. It's sad. Very, very sad.
Well, that's how we all met each other.
I know.
Yeah.
That's true. Yep. And I'm like, damn, like, not only has it only been almost been a year, but like, she was so excited to see this trial through. So it's like, I have to believe she's, up there sort of watching us do this, like, because she would have wanted to see this entire thing through.
Yeah.
What are you talking about? She went straight there and found John O'Keefe and got the best interview.
I know. That's probably.
Yeah, she got all the deep.
Yeah, she got it straight from the horse's mouth. God damn it!
Yeah.
Like,
and she's not sharing with us.
Yeah, right. So you can give us a sign, like that would be great. That would be great, right? Imagine she probably did get the best interview ever.
I want to know what Karen said.
I know, dude. Like, I want it, like, because I have to believe that, like, they were arguing when he got out.
They were drunk. Yeah, she wasn't a nice drunk. He wasn't a nice drunk. They
No,
were
and she
fighting.
changed her story like 57 and a half times. Like, first it was when he got out, she didn't know if she could have backed up into him, if he was behind the car, if he dropped his phone. Then it was she saw him walk towards the door. Then it was she saw him get to the threshold. Which one is it?
Yeah, sometimes instead of changing the story so much, I think they'd have been better off just sticking with, well, you know, we all know I was intoxicated. I don't remember.
She'd have been out by now.
Yeah.
Like she'd have been out by now. If she had stuck with Yanetti's first original.
And we're supposed to believe these lawyers aren't getting paid.
Here's the thing. I'm sorry.
Come
but if
on.
the defense really
You
wants
know
to
how
sit
much
there,
this is costing them?
and that's another thing, you're going to sit there and say, like, oh, well, we didn't know we could pay ARCA, or like, I'm sorry. But if you're getting an expert witness, no matter who that effing witness is, you're going to know you have to pay them. How many trials have you done as an attorney? You damn well know that you're going to have to pay them. So to sit there and act like you're not going to have to pay them is just absurd. Like, absurd.
Yeah. You're not getting no witness report or testimony for nothing. Heck, like I said, our witnesses didn't even testify because it's settled an hour into the first day of court, and they still all got paid.
I know. Like, ridiculous. Like, oh yeah, Bella's mom. That's right. That's why she flipped out, because she thought, you know, John was in cahoots, having some sort of affair with Bella's mom. She would have been out before last April. Oh yeah, Alan. I can't. I mean, that's the thing though, right? Like, you have to believe that they were in some sort of argument when he got out of the car and she got pissed. Like, she's also changed her story about, first it was she didn't know if they were invited, right? So John was supposed to come in and then come back out and tell her. Now it was they were invited. In the latest interview, she's not doing herself any favors. She's changed it like 72 and a half times. I don't know why.
I just hope that, I hope the jury sees through all this time.
Let's hope so. I mean, Hank's got a second bite of the apple, right? And he knows what mistakes were made in the first. So I don't think it's a good like, how do I want to put this? I'm going to do this very specifically. Sorry, I got distracted. Now I lost my whole train of thought. Like,
are you going to cover the Turtle Boy side of it too?
Yes.
When his trial starts? Yes.
And then
I'm going to be all over that.
I'm going to throw a very large party when he gets convicted.
Yeah.
Yeah.
Be right there with you. Definitely covering
victims. Yeah, we're going to have a good old time.
The shit that man did, no one should ever get away with. And he's been getting away with it for far too long.
Shit, he still does to this day. Like,
he's been getting away with it far too long. Nothing's changed.
Nothing. Not a single thing. Like, I want to know when Massachusetts State Police or when Cosgrove is going to, no offense, but like, kick it up and do your full job. Not just turn a blind eye to some of the crimes because he's already got 19 indictments. You can't just say like, oh, somebody's been indicted 50 times on 50 charges and they can commit another 25 crimes because I got to work on the 50 they already committed. No. Like, all you're doing is showing the world that if you make, you commit so many crimes and you're indicted for those crimes, like, that you can just keep committing crimes after that and they're not going to be bothered with doing anything about it because it's too much work for them.
Boy, that's
I agree because he stayed out of. Sorry, Voices. Go ahead.
No, I just said that sounds like Betty's situation, doesn't it?
Exactly.
Yeah.
They're charged. They haven't shut up. They violated the orders, and he went to jail. She had to post bond, and neither of them have shut up. Have continued the same behaviors.
Yep.
And worse, escalated.
Make a mockery of the court and the whole system itself.
And it's like the courts are doing nothing. Yeah. And we're talking 2 different states, Massachusetts and Tennessee. And the courts have just said, okay, well, we got them on something, so we'll get them.
Right.
Go ahead and let them do what they want.
You're talking about the courts, the DA, the like, I understand 19 is a lot, but if the man is out there sending threats of blackmail and extortion to people to quiet them, and literally still intimidating witnesses using different tactics, such as making sure you're in front of the pool camera so you can put things on the screen of your computer that you're never typing on, but that you always have to show the screen for, like, that is unacceptable, period. And the judge should have not allowed him in the courtroom a long time ago. But now with these shenanigans, he absolutely should not be allowed. Actually, his press pass should have been pulled already. Like, I'm sorry, but like, he definitely, in my opinion, violated the restraining order numerous times. And no matter how many times you report it, if they choose not to violate him on it, what good is the order then? What good is the order if you go and report violations and nothing is done? What good is it? What's the point?
I
Why?
mean, that's the same thing that's going on with Betty right now.
Yeah. I saw that too. Like,
I mean, why make her post bond? Why even go through all that? You're not going to do nothing.
Right.
I mean, she went as far as the judge told her, these people no
Don't
longer
exist
exist
to you
in your
world. Yeah, I saw that.
And she went and got a freaking tattoo.
Oh, I can't. Like,
straight up, got a tattoo.
And continues to accuse them of everything under the sun.
Oh, from SA to abuse.
Like, it to me, it's like a very big failure of law enforcement and the court. It's a failure. It's a complete and utter failure to victims. And it's a slap in the face of the entire judicial system. Do your fucking job. And I don't want to hear you're afraid because they might smear you or your, friends. Like, come on, dude, or your family. Like, you signed up for this job to take the bad guy down, no matter who the bad guy was or what the bad guy did. So you don't want to do anything because you're afraid he'll smear you, but you're okay with him smearing other people and ignoring it. Got it. Make it make sense. You got
the people that have protection orders against you. You were still harassing, still stalking, still threatening, but that's okay. You go ahead and do it because we already got you on another charge.
Right. Like, that's the thing. It's just insane to me. It's like, do your job. You guys got into this to put the bad guy away. It shouldn't matter who the bad guy is or what you're afraid of the bad guy saying. Okay. How do you think his victims feel? They don't have the power to make sure he's held accountable. You do. That's your job. They do their part by reporting it, and you do your job. Now, if they hand you evidence, if multiple people hand you evidence, why hasn't anything been done? That's what I don't understand. If there is ironclad evidence that they have handed you, where's the charge? Where's the indictment? Where is it? Where's the arrest? Where? We're just going to ignore it like it never existed. And then like, oh, but like there's these ones that have already like, no, that's not the way the justice system works. You don't get to say, oh, well, we got enough work with the 2,100 ones that they already have. So like, unless they like come to your house and like murk you, like we're not going to charge them. So you're saying that he can commit any other misdemeanor or felony as long as it's not like killing you. Like that's just like, you guys won't do anything unless it's like actual, like coming to your house, knocking on your door, punching you in the face or like stabbing you. Like is that where we're at? Because I don't think somebody should have to take their own life for them to wake the fuck up. I don't think that someone actually snaps from being harassed or bullied and they hurt someone else for something to happen. Because at this point, like that's where we're at. There are so many victims, like you never know. Someone may snap and hurt themselves, or someone may snap and hurt him. Like why does it need to take like some sort of tragedy for something to happen? Like that's not normal. No one needs to be hurt in any way, shape, or form if they just like did their job. It's, you know what I mean? Like, I just don't get it. Like bullying will push people to the brink of wanting to hurt themselves. My dad committed suicide. Okay. He wasn't bullied that I know of, but my dad had a lot of demons, like, and things that abuse that he lived with, that he didn't tell people about when he was alive. And that ate him up inside, and to the point where he took his own life. Okay. We've seen kids who are in middle school or high school even take their own lives from bullying at school. It is a psychological torture. And some people will do anything to make it stop, even if it means ending their own life to make it stop. Like, that should never happen. That shouldn't have to happen to hold somebody accountable for their criminal actions that are leading to that. Incitement is a crime. Inciting a mob is an actual crime. Like, do something. Lying to people to incite them, like, that's you're willingly doing that. Like, you know what could happen when you do that. Like, if they just actually kept it on the up and up and, like, you know, held everyone to the same standard. Can you imagine if one of us did some shit like that? We'd be waiting for bail right now. Like, we'd be charged and sitting in a cell. Like, no one should have to think that there are rules for some people and not rules for the other. It's across the board. You commit a crime, you have the consequences of said crime. Those consequences need to apply to everyone, not just some people. And not, oh, well, I'm afraid of losing my job because he might lie or smear me. And then there's an investigation and they found out one time, like, I put a wrong number on a paper and they fire me. Like, no one should have to worry about that. And, like, that's also law enforcement's job to, like, make sure that, like, no one gets to just, like, point fingers at the people investigating them and say, oh, they must be corrupt or it's a big setup. And then you then go investigate all the people who are trying to put this person behind bars for doing bad things. Like, because that'll just be an endless loop of nothingness. The man's a proven liar. It's not really hard to figure out. Like, he's going to point the finger at everybody but himself. Always has. Everything is a conspiracy to him. Everything is a conspiracy. He's always set up. And if you go way before this case, like way before this, what I found, like, forever ago with, like, messages that were leaked from, like, admin chats with him in it and all sorts of shit. Way back then, he was claiming he was set up and it was all a conspiracy and it never happened until later on. Like, we know that he had to admit, like, some of it happened and some, like, so it's like, he's been lying for years saying he was, quote, set up every time something happens. Every time he's caught doing something, it's a setup. It's a conspiracy. Like, everything isn't a conspiracy. He can't have had everybody set him up every single time he does something wrong. Isn't that convenient? Like, stop it. That's ridiculous. Once again, not rocket science. Well, at least you would think it's not rocket science. It's not to normal people. To the cult, it's rocket science. But to normal people, it is not rocket science. Like, Occam's razor, dude. The simplest answer, which is, he did it. He is guilty of doing bad shit. Like, it's not hard. Time is it? 1:52. What the hell? Oh, is this supposed to be like a commercial? So what was that? What that is? Oh, it is a commercial. But it's still Fanny, so we're good. It's still Fanny.
Riverside. It's a podcasting audio.
It's still Fanny the Fan. We're good. I cannot believe it is literally lasting this long. Like, my kid's going to be home from school and it's still going to be going. Like, this is insanity to me. Like, I'm hangry now. I need some breadsticks or something. Like, I need a snack. That's what I need. Actually, I'm going to shut my computer screen off so I can go pee real quick so you guys can't hear me pee.
Oh, you're fine. We can hold it down.
Yeah, we're here.
Hey, Spitfire. So,
hey, everybody.
Oh my goodness, I got Happy Mail.
You got Happy Mail?
I got Happy Mail, and I think I know
Damn,
what it
you
is.
always be getting Happy Mail. I'm jelly.
I think I know what it is. I'm pretty sure it's gonna work out real well.
It was a nice surprise the other day from Beautiful Disaster.
Yeah.
So, I appreciated that. The kids sure did too.
Oh my goodness. Oh boy.
What?
Hang on. Let me show you what I got. Hold up. It's going to have to be charged. But oh no,
You
everybody's
got a
in
freaking
trouble
microphone
now.
out.
What happened?
I knew
I got
somebody
a
was going to buy you one when I said
microphone.
that. And mine's just a blow up one.
Boy.
I know, Jennifer, he does. It's really obnoxious. And if you guys didn't see my sign, I bought this on Temu. Okay. This thing is so bright. Like you can't, it's so bright that my computer can't even pick it up. But it says do epic
boy.
shit. That's what it says. You can't even read it because it's so friggin' bright. The computer's not even picking it up. But it says do epic shit. That's what it says.
Oh,
I was
you
gonna
need that
put it-
between you need that on the wall between those windows.
I know. That's what I was going to do. I was going to put it under Justice Ave and Twisted Tragedies over here, but you really can't still even see it. Look at how bright it is.
Once you pull it back, you can see it.
Like, dude,
Because
this
you see it.
thing is so bright. I think I paid like $7 for it. Like those, the ones that I had made, these two, that one, the bottom one, the one that says Justice Ave is made to look like it's a little older on the edges. But the Twisted Tragedies one, I think I paid like $6.71 or something like that. Like for that one, and like the bottom one, I paid like $5 for. Like, thank you, Temu.
That's cool.
Right? Like, I also have a sign over here. It's up there above all that stuff. It's teeny tiny, but it's up there. And it says, I was taught to think before I act. So if I smack the crap out of you, rest assured, I've thought about it and I'm happy with my decision.
Yeah, we need that one.
We do, right? Like, legit. And then I haven't hung these ones up. They've been sitting here for months. But this one says, remember, if we get caught, you're deaf and I don't speak English. Because no one would be able to talk to the cops if one person's deaf and one person doesn't speak English.
Right.
And this one says, my mouth has no filter. I say whatever I please. And most of the time, I'm just as shocked as you. And I don't know how many times I've told you guys I cannot be responsible for the things that fly out of my mouth. But this sign basically says so. Like, I cannot be responsible for the things that fly out of my mouth. Like, I do. I love Temu. I'm not going to lie. I've gotten a lot of really nice things on Temu. I don't think there's anything that I would return. Like for decoration, I got these guys and I still haven't even like added
I've never bought from Temu. I've looked at it a few times, but I've never
nice,
actually bought anything.
I have other ones that have white feathers and dark pink ones that I still haven't unpackaged that go in these. But I have two of these. And they're like fluffy feathers almost, but that don't like molt. And in a little vase. The vases came separate, obviously. But I have two of these. And so they stay on my shelf, one on one side, one on the other. And I got the dark pink and white ones that I'm going to add into these, and this one and that one. But like, it looks adorable where it sits in my house. I also got like, you know, those little plates that you put over like your switches and your plugs. Well, I decided that I was going to get, hold on, just had one of them yesterday. I was going to get a bunch of them for the plugs and the switches. So I got pink ones. This one I haven't put on yet because I just got them like a month ago. And they are shiny bling pink. And so I got them for the plugs and the switches in the house. And once again, Temu, they came in like a pack of 5 for like $3. Like, and they're like heavy duty. They're not like cheap. They're pretty heavy duty. So I got those, which I happen to love because I like everything pink, and Karen's not going to ruin pink for me. She just will not. It's my favorite color. Like, see, I have never shopped on Shein before, although I probably should because I need clothes desperately. I have not. I bought a few things from Temu clothes-wise. This shirt actually being one of them. There's another shirt I specifically bought for the show that says I'm a special kind of twisted, and another one that says I'll let karma deal with it. Otherwise, I'd be in jail. But I got some really cute like shirts and leggings on Temu because I like skulls. So I got pink It has like pink flowers and skulls on one pair of leggings, and I got a pair of canvas shoes that match them, that are comfortable for the summertime. The shoes. Why are we still looking at the fan? Hello, it's like 2:00 now.
So, Judge, she wants to drag this out till next week.
Like, for real though. Like, I'm gonna eat these Cheetos so that I'm not hangry. But like, if I have to listen to Alessi talk for another effing hour, I might gouge my eyeballs out. Like, bro, you have said it.
He needs more time.
Well, he said the same thing 17 times, dude. Like, like, come on, man. Like, we don't want to hear you say the same thing 17 times. Sorry. Like, yeah, talk and say nothing. He talks and he says absolutely nothing. Like, insane to me. Like, oh my God, I'm dead. My friend just sent me something weird funny. Okay.
Oh my God. This microphone changes my voice.
Some people love my voice and some people hate it. Like, when I'm in public sometimes, some people will literally walk up to me and be like, I know your voice. And I'm like, you sure? And they're like, yeah, where do I know you from? And I'm like, do you watch YouTube? And they're like, oh my God, yes. That would be it. That would be it. I've heard that so many times. I'm like, it's not my face. You remember it's my voice. Gee, what a compliment. It would make sense if it was someone from like out of state. It's funny.
What was that?
Kid had one of those
That is the stupid microphone that I got, Kathy.
that does that. Oh, it's pink. I love it.
It's pink. And it will totally change my
Okay, so now we got to review Julie, and you got to break out your mic, because mine's just a blow up one. It don't really work.
By the way, if you guys don't already watch Court TV in the morning, Julie Grant is on at 8 a.m.
Good morning. It is Court TV recording, and we are watching Fanny the Fan.
I wanna hula hoop.
I wanna
Chipmunks. Hilarious.
All right, come on, Judge.
I know. Like, listen, lady. We all want to get on with our days here. And we all want Alessi to shut the fuck up. Because, like, I think the guy just literally likes hearing himself talk. Do you notice how, like, when he says, like, a sentence, he'll take either a word or a part of the sentence and then just say it louder? Like, buddy, we heard you. The first 17 times you said the same freaking thing. Like, we don't care. Get to the point. And it's like, maybe if any of his arguments had like a point, like if your arguments had any merit or any teeth, right, to what is being like accused of the defense, like, then cool, then talk. But like, literally none of it is relevant. Like, none of what he has said thus far has been relevant to what they're accused of. As a matter of fact, shot himself in the foot numerous times. Like, oh yeah, we paid it. Oh, you paid it. You paid it. But still to this day, remember, there was the invoice, but still he's talking about, oh, well, we gave it to them on the 12th or the 13th of February, like just now. Where's the paid bill? Where's the information that you paid said bill of that amount? Because still to this day, you haven't given that. We had a bill that ARCA sent to the attorneys, but no receipt of the bill, no if you actually paid it or not. So like even to this day, you did not. You can't act like you told us and you magically told us on the 13th, so that satisfies the requirement. No, it fucking does not. You've had the information for a year. Like, stop it. Like, I don't think anybody besides me, because I have to listen, remembers anything he said. Like, he literally did. He literally spent 2 hours being like, blah, 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 them. Don't look here. Not me. Can't be Mr. Yannetti because Mr. Jackson wrote it. Blah, blah, blah. You said, Your Honor, you. And what you meant was, these are the definitions of the words that you said. Like, the fact that he even went there, like, you literally just patronized the judge. You insulted the judge's intelligence and you assumed what she meant. Like, don't speculate, please. Like, that was the stupidest thing I have literally ever seen an attorney do in my life. You risk pissing off the judge. I'm so confused. Like, who would ever tell him that is a good idea? Like, at this point, I just don't think they had an argument. And like I said on Twitter the other day, my best guess was that they would try to deflect, blame the Commonwealth for stupid, be like, well, the Commonwealth did this and the Commonwealth did that and Commonwealth, which is essentially a couple of times he's done that, and then try to sort of word salad their way out of it. Well, we use this specific word, Your Honor, and that's because like, so he's not even really saying that, because then you would be like admitting to like misleading anyway. But it's like, the judge doesn't care about any of that. She cares whether you gave over the information you were supposed to give when you were supposed to give it, or if it's just coming out now because you had no choice now. But that the first trial's over. So why wasn't the information given when you knew a second trial was going to happen right away? You had the information. Why wasn't it given over? Like, come on now. Stop it. They didn't give it because they weren't in going to. Like, I feel like they knew. Oh, I think it's coming back. We got a judge.
Attention, ladies and gentlemen. We have a judge entering the courtroom.
We got a hula hoop.
Boy, they don't look too confident, do they?
Nope.
Please, the court. I first want to thank Your Honor for the generous amount of time you're recording.
Need to thank me. Just go right ahead, sir.
Just keep going.
And take your
up.
time, Mr. Alessi. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan. Substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote the, and it's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept, because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11. Hi, Alan. Subsequent to our conversations, he's quoting purportedly this email. On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?
What just
Your Honor,
happened
there's
on my
not
screen?
one
Hold on.
mention of the word pause in that quote. The word pause was left out
What is
of that
happening here?
quote.
Here it is.
That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that pause was not quoted.
I mean, what the defense
on
does,
page 57.
basically every motion.
Now back to page 60, or excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts. So I want to try as my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth,
okay,
providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access.
I don't think he knows where he's going with all this.
I don't know the answer to that.
Into a word salad, back out.
Go right ahead.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And
do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get
Just if we can, because I'm looking at a calendar. If you don't, I thought you may have had it. We can move on.
I believe it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA, reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confer with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like this, ARCA is amidst a sea of other topics.
So shameful. It's so
right?
ridiculous.
This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think, I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have with, on page 58, we have another incorrect statement. We have two of them right up off the top.
But yours are just
And then we
miscommunications,
continue
right?
on to page 59.
God, with your bad self.
Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
You
And Your Honor,
believe?
if I may, I want to give you the second.
Well, you
but the
know
basis for that
what
answer is
the judge meant.
Page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got.
It wasn't.
It's not dated. It's not dated. Now,
So
let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you're, thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so that itself is not, I understand it's with the email, but it's not dated separately.
Well, Your Honor, I was going to get to that, but there's
Well,
context
what?
for that.
Oh,
Go ahead.
please.
The context, you're correct. The outline itself is not dated. However,
That's what she asked
the
for.
attachment,
Dumbass.
keep in mind, we produced these materials.
Okay.
So
Relevant.
we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Okay.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor. And I
So
appreciate the question.
what is the date of the, so you're saying what I referred to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one? When
The
was
other one
that sent?
was sent the day before on June 22nd.
Okay.
I'm just going to give it the name that the email has. I think it's @wolf_qualls document. Okay? So there's two emails. One's just the qualls. The other, I respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual qualls document or the direct document. We produced them in this fashion. And I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that
I'm going to ask you to hold that thought. I just have one other thought about
Yes,
this. So
please.
we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you're
correct.
saying that this was disclosed prior to the February 18th hearing. But was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That I
answer-
just wanted to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Building your online business? Go to Wix.com and set up your store on a single integrated platform. Add products, showcase them dynamically, and seamlessly.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the Voire. They had it 4 months ago, 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it?
Duty school dropout. I know,
Is
right?
the Voire
I catch the cat.
June 18,
I'm hungry.
2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, et cetera, et cetera. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, This is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree. It would have been, and you did. Twice. Next.
He meant the actual
Reading on the same page 16.
discovery, as in like the whole thing on that paper.
Specialty in the area of lighting and human
Idiot.
factors
It's not a
results in a lot of
misstatement.
my cases
A
involving
misinterpretation
pedestrians.
by you.
That's the end of the quote. And then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree. And you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry?
Yeah, that's what he meant.
Don't tell them.
He said what he meant. Meant what he said.
Twice. In the voir dire and in the direct. It was just unvarnished. And here's the important part, Your Honor, another important part.
He got this from the
Mr.
cult.
Jackson drew that out
That's
on direct.
not what he meant.
Not only was he not shushing or hiding,
He meant,
it was Mr.
don't
Jackson's
tell them about-
question that drew that out.
it wasn't about the
here you have
question.
Dr. Wolf trying to figure out, is this something that we should
about
say?
the-
We're not in
The
honor of
actual emails to begin with.
Mr.
It's nothing to do
Jackson.
with the context of it.
No,
It's the
we're gonna
whole
hit it
thing.
head on.
Would have been nice to have the
Mr.
whole
Jackson
thing.
draws it out, puts it right on the table.
No, you
4 months
misinterpret
before February
on purpose.
18th.
You got it from the cult. Got that
And the
argument,
whole
that
world heard it
excuse
live.
from the cult. Stupid
Next.
excuse, by the way.
If you could, Your Honor, please go to page 60. I'm sorry. There's another point at the no. Let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped.
Correct.
So Attorney Brennan,
God, me
didn't
too,
know any
Anna.
of this.
Me too.
But I've tried a few cases. I've been around the federal court a bit. I know how it works.
Yes, he does.
So what is the import of that statement? I didn't know any of this until I got it from the federal government.
Oh, please.
And we're talking about the invoice.
It's irrelevant. He didn't know
No.
it, period. Until he
You
just
know
got it.
about
It's
because the
irrelevant who
defense,
gave it.
After the certificate of completion of discovery, and 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made. Sometimes parties pick sides, agree, blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of.
That's what you did.
I choose
What you did. That's what you did.
to try to comport myself and practice.
No,
a
so you
certain
weren't
way
there,
and
so I don't
give
even know why
people a
you're
little bit of
speaking.
The benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields,
What you guys have been doing
I
for
don't think
3
it's the
years.
defense
Ghosts
that's
and
creating
illusions.
Ghosts, illusions,
Hilarious.
and shields
Yes,
here.
we have. Yes,
The
you.
illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion. It's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used to, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpreted as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line, page 60, line 13. I don't care if the ARCA witnesses testify at trial. Very pleased to hear that.
They don't care.
I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden.
And it was. So
And that is based
where's your
upon the
evidence it
faulty
wasn't?
premise
Oh, you have none.
that we
That's right.
didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with them. The Commonwealth is entitled to discovery, and you got it 5 days before.
Oh, for
February
fuck's sake, keep
18th.
saying that. It's not going to save you, dude.
Now comes
It's not
to
going to
the
save
point.
you.
All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what
You thought. Nobody cares what you thought, though.
Sure,
There's
Your
no
Honor
difference.
listened to a completely counterfactual rendition
Counterfactual.
of some of the most important issues
Oh my
of the day and frankly of the moment in this trial. And the reason I've got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court saying the break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy.
Or you're misreading it on purpose.
Are you misreading it?
He's mischaracterizing it. It's like so funny to me.
I know, but misreading it.
Yeah, misreading it.
And then the court comes back.
He's got to accentuate random
And
words.
I understand. I don't.
Like he's delivering a soliloquy.
Really, and I'm going to get to this.
Notice he keeps his eyes closed half the time too. Like you can't look the judge in the eye, no?
The justice in terms of this presentation to the
Christ,
facts.
I thought he was going to fall
And that's
over.
what we're going to be talking about.
Like, bro, he doesn't
Facts
even know
and
what he's saying
representation.
right now. He's just
here's what the
spewing
court
words.
says. After hearing all of this, and I want to underscore something, Your Honor.
You want to underscore everything.
And I'm not going to get too lofty with due process and notice, but it's important to hit some of these points.
You're right.
All of these topics that
Public
were raised
trial,
were
that's
not
important.
in a motion.
He's almost
They were
out of
not
his
in an
time.
affidavit.
He's almost at
And
45
I've had
minutes.
this issue before with other
Somebody run him out of
motions
gas.
under what's required in an affidavit.
In this case?
See what I did
Or
there?
you're just saying generally you've had this issue in other cases, or do you mean this
Other
case?
cases,
Okay.
other cases, Your Honor.
Have you?
With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of.
You, Your Honor.
We had no notice
Subjected
that
to
was
our
going on.
lies.
There was
This
no
is crazy.
affidavit that someone had to swear to that all of these facts were correct.
And they were.
And Your Honor takes the break, so we didn't get an opportunity to
You
stand up and
had
say,
one.
when I'm being given the
They
very
had
full
one. They said
opportunity to
nothing.
say today.
Stop
So
it.
Your Honor comes back. All right. So the Commonwealth just provided the court with information.
Use the same
And I don't
argument in
even
the
wanna repeat
SJC
these
didn't work.
words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. but it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again.
He knows what she
and then-
said,
and then
once
the rest,
again.
So be back in here.
Yeah, he's blaming the judge.
Unfortunately, that's not the end of the prejudice. So what happens
The
is
balls.
all of a sudden, and Your Honor basically said, and this is
The
this is
balls.
so key. So you said, I'll see you in a week from today. And then Your Honor continued on page 61.
Me too, Val.
Line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read?
I know.
It was only then, when the specter,
Oh,
not
wow.
specter, the reality hits,
I can't.
that you're looking for the backup for what's being said.
What?
Up to this point, Your Honor's understanding, all of this came from the feds and
It doesn't matter who it came from. I don't think you understand that.
So what does the
judge doesn't
Commonwealth
matter.
do?
She doesn't care who it came from.
Does the Commonwealth stand up and say, whoa, wait a minute, I've made a mistake.
They did.
And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I have to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and
Oh,
said,
you guys
Your
have had the
Honor,
courage to say a lot of
you know,
lies
this is that.
in
But
the
that
court.
didn't
So
happen.
please,
So what didn't happen?
save your pearl clutching, sir.
The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of.
I love
So
watching
the
the
defense is still
reporters'
not
heads.
able to get up, but the Commonwealth is
Every once in a
continuing
while,
on.
they're like,
If I could
"What?"
add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office.
It's been an hour,
saying that
bud.
the
Come on.
contract had ended with the
Wrap it
ARCA
up.
experts, and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said,
Doesn't matter.
the federal government, it was the defense. February 13th, they sent us the emails in the direct
It doesn't
examination.
matter who sent them. It doesn't matter. It's
I think I
irrelevant.
said, that was
Dumbass.
the whole basis for the entire presentation.
No, it wasn't.
Was that the Commonwealth had to fight even the feds to get that.
No, it was that you never gave it.
And then it
Period.
goes on. We reached out to the federal government.
Dumbass.
But you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected
Please.
that the invoice came from the defense. Just the emails.
I thought it meant everything, but
I don't understand how that conclusion could be drawn, Your Honor. You didn't say the defense
You yelling at
provided
the
us with
judge?
all of the entire production.
The
The
fuck?
defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached
it was
out to the
because I received a copy of it.
Pardon me?
Right. I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you got to correct
Which Brennan did.
material.
Right away.
And I've got it in front of me, but I'm just paraphrasing.
Weirdo.
I want to get to precisely. But that's why I perseverate this on this, Your Honor, because
Yeah, came from the defense.
I trust
Irrelevant,
that the court's going to hold
because it wasn't
everybody
given
to
to the
same
Commonwealth till
standard.
now. No matter who gave it.
And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do. But if we're going to start looking at
let's
comments
start
of
pointing
defense counsel,
fingers. Here we go. I
believe
called
we
it.
have to look at all comments.
Oh,
And again, I'm
please.
going to go back to my own view is this. Being a lawyer in cases like this is hard. Being
This
a
is
judge in
such a
cases like this is
bad
hard. Mistakes
look.
are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement.
Yep, so
because
interesting. Get to the
you
point.
read it because that would naturally preclude the defense from retaining them. Yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCA.
Yeah, for other
So then
reasons.
the court goes on. all
Dumbass.
right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point.
This guy's really bad at his job.
I don't believe you're at honor on
Just
any
saying.
basis before that to believe that it had come from
Pissing the judge off further.
I'd like a copy of
Good
it
call,
before you leave the
dumbass.
courthouse.
Right before you have to
I harken
argue his
back,
own
Your
motions.
Honor, to
Dumbass.
what I conclude drove Your Honor to make
The statement.
those impactful statements
Oh,
about
please. Impact.
on the top of page
Stop it.
61 was the presentation of the Commonwealth that I counted had 10 misstatements.
They're
10
not misstatements.
before,
You
Your Honor,
say they are,
pause,
but they're not.
pause. So
You want to go over every misstatement the defense has made? Let's start with the Fed's statement y'all made, and then the Feds had to come out and actually say that that was never
what
said.
happened then?
How about that one? That was pure lie. Yeah, it
The
is.
Commonwealth having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit.
Yep.
We didn't have the ability to stand up. But I will
Yes,
tell
you
you
did.
this, Your Honor.
You have legs
I greatly
and a mouth.
appreciated the week that we got because I do believe that Your Honor
Oh,
intended
you
that
appreciate
counsel be given, defense counsel and defense, a fair opportunity to go look at this.
Well, but you
And
couldn't stand
that's
up and
the
say,
way
"Wait, Your Honor."
I'll speak for myself.
Stop it.
That's the way I took it. and I
SJC
appreciate
slapped that down
because
already.
That's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court,
Bingo.
I believe that is a sacrosanct duty. And in a matter where
Please.
the very issue is, what are counsel saying to the court and is inaccurate? I wanted to make sure I could do the best I can. Now,
Savior,
I
pearl
may have
clutching, my
made
dude.
a mistake
Over.
here or there, but I just want, and today, but I want to make sure that I recognize Your Honors giving us of that week, and we've tried to take the
That's
best
great.
opportunity.
Move
for it.
on.
So what happens?
Fuck.
What happens after these 10 misdirections?
You talk for 4 hours. That's what happens.
The court's comments go viral.
Oh, they went.
And I'm not saying this
Wham.
for drama's sake. I'm saying this for what has impacted the defense
Wham.
6 weeks before trial starts.
Oh.
Jury notices are out in the mail.
Oh, man.
Those words,
But the statements you all have made that impacted
based
Jerry.
upon the misdirections that your court
There's no mister.
had to endure,
Yeah, the ones you've given.
have gone through, and I'll just name a few headlines in the Globe, the Herald,
Oh,
every
no, not
TV
those,
outlet,
those
social
headlines.
media exploded.
Yep. Say it again, freak.
These
Darvo.
are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided. had there been an accurate recitation
Oh,
of
please.
what had occurred. And Your Honor,
There was. You're just
I don't
mad
know
there
if this
was.
can be remedied,
You're right. She's gonna have to remedy it with tossing someone.
but it surely shouldn't have been exacerbated.
You guys haven't exacerbated lies for 3 years? Stop it. I can't. I literally can't.
I would now like to move.
You're insulting
rather
the judge right now.
hopefully efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because
Again, you don't have to tell me what you're going to do, Mr. Leslie. Just go ahead and do
go ahead and do it. My apologies. So now
Shut
let's
up already.
just
That's what
turn
she
to-
wants, is you to finish and shut up. Right? Toss someone, God damn it. Toss his fucking word salad fucking ass right out the courtroom, dude, along with the fucking sewer turtle, Mr. Burns, and the rest of the public seats that they're selling in their raffles at the moment.
Model Rule 3.3A1.
I know. Like, bro, shut
This
the fuck
applies
up.
to every counsel in this room, of course.
Ugh.
A lawyer shall not knowingly. So there's the adverb.
Well,
of the
why
mens
can't they
rea,
speak for
knowingly.
themselves? They want to speak
Make
every other
a
day.
False statement
I
of
find
fact
that
or law
interesting.
to a tribunal.
And you have
Or
many times.
fail to correct a false statement of material fact or law previously made to the tribunal by the
I
lawyer.
sent Paul a
So
message
we
the
all
other day letting him know we
the
all
mens rea
have his back.
of knowingly. I don't, and this court knows it better than everybody, so I don't have to get into that.
You're
But
right. Please don't.
in terms of make a false statement of fact or law to a tribunal,
I think she'll give him one because they're accusing him of misstating
I
things.
don't
Which
see that on
he didn't.
behalf of the defense, and I'm going to get to the
Oh my,
new
get
item of
to
February 6th.
all of it. Get to
Covered
the
that,
end,
Your Honor,
buddy.
Brought that up today.
Shut the fuck up.
But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that
Oh,
time.
sure. I'm sure they were.
100% true and accurate, and that's why I went
Yep.
through the
Just like the statement you guys made about the feds a year ago was
failed to
so
correct
true
a
that the
false statement
feds had to
of
make a
material
statement
fact
about
or
how it
law
wasn't.
previously made
Got it.
to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing a statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you know, you got to correct them, right? And what they talk about is what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false of material fact or law.
Yeah, you did.
And material
Check.
has been interpreted in the context of 3.3A.
Oh, we want a word salad. What material
to be
means?
a statement of fact or law that
It is a law
caused
for separate
a
discovery.
court or adjudicator
Yep.
to have relied upon it for a determination.
And she might have.
Essentially what the case law talks about.
So-
that it's influenced the judge's decision.
Correct.
So let's go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had,
oh my God,
it's the same lawyer that we're talking about in both clauses, and that is why I spoke about Mr. Yanetti's
You using your glasses?
about what he knew.
That should
the
have
fact
never
that
came out of
Mr. Jackson
Okay.
was handling the ARCA experts.
What is that?
So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the
on a
analysis
2019 Chevy Colorado.
with regard to
Yeah, I got it.
3.3A1. And as I said,
What?
I'm keeping
I didn't hear you.
separate 3.3A1.
Just wanted me to mute you because I could hear background noise.
Different analyses.
Oh, I was muted.
But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to.
Just do it.
Now go to.
Shut up.
What Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time that?
I don't. I have taken the time. I appreciate the offer.
Oh, good.
But I would like to draw
Taking
your
enough time of the
attention,
court's
Your
time at
Honor,
this point.
because like I provided context on June 10th, I think context for February 6th is important.
Oh,
And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is.
okay. You want to keep.
So I have that entire
context for the next
transcript, like I said.
17
What
hours.
page are you at?
I am starting on page 40.
Oh my God. I can't.
Okay.
I start with line 1.
You didn't, Bree.
Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with? No, okay, I received it. I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you.
I know.
So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled to.
Sorry. We're not missing much anyway, so.
18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions.
Sure
but
can.
on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court move to exclude the witnesses. Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right, last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides' discovery. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than waiting. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when
She
the
has.
Commonwealth has
I had
the
a Rule
exact
14 violation.
same
The judge
batch
found.
of information that we have about these?
I know.
witnesses? And there's more context to that. I understand the import of.
I've been watching them.
So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th,
please.
when then we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it, with other side be seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery.
Oh, that's
Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is
anything
in the possession from March 22nd.
Knows
not
nothing,
recalling
folks.
all of those items.
Jackson doesn't remember
That was
anything.
Ms. Little's responsibility. So
Here we go.
what
Splitting
happens?
hairs.
What happens is
Doesn't matter
Ms.
what
Little
happens.
handles the production, goes back and does the diligence that she always does, takes all
Bingo.
that material, sends it over to the Commonwealth.
Bingo. Even during trial,
On
you handed it over.
February 18th,
You had it. You didn't
the
hand it over.
defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully,
It's been 45
whatever
minutes.
the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him. He can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had.
Who's he yelling at?
Those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had
Exactly.
the direct, we had the quals, not running away from that. But the question
You had them and
is,
didn't turn them
at
over.
the time
You are
Mr.
running
Jackson
away.
made those statements,
Stop
he's
it.
focusing on the government.
Oh,
And
please.
he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back
Well,
when.
that's not an
And
excuse.
so with regard
Your
to
responsibility.
the shall not knowingly,
That wouldn't be one for the Commonwealth. It sure is not
there's
for you.
no evidence of knowingly here. And I don't believe,
Bullshit.
respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances. So knowingly is not merely a subjective question of what an attorney has, the court is entitled to look at the circumstances and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis. And I'll give you some examples.
No fact. She's got
What
plenty of
happens is
dumbass.
if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did is she said, no, I didn't know it. I didn't remember it. I was under psychological stress. And what the court did was they went and they looked at the circumstances.
But he's not under
and saw
psychological stress, and he's an
emails
attorney.
and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she didn't. So there's an example of you've got to have circumstances that the court cannot just jump from. A lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the only
horrible arguments.
Respectfully, that's the only aspect. And I went through all the others that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In some, Mr. Yannetti's statements on June 10th,
they're false.
All completely accurate.
They're
all
false.
Completely accurate.
False.
Mr. Jackson's eliciting of the direct testimony at trial when he asked, have I ever asked you specific, questions, etc. That's completely true because it was Dr. Wolf who sent the questions in.
Oh,
so
please.
We now are left with February 6th.
We're splitting hairs and insulting the judge.
That construction of the statute. My last point, Your Honor, is going to go to
finally
the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows,
Come on, bro.
that the
Shut the fuck up.
discovery came from the defense.
It's
I want to
irrelevant
go back
where it came from.
to please.
I don't think he
February
grasped that.
18th
Doesn't
transcript.
matter where it's coming
Because I
from.
want to keep separate analytically the
No, because there is no precedent for that.
ARCA from defense counsel. Because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point.
Oh, she has the right to choose her counsel, not if they're committing
what occurred,
crimes like perjury.
I wanna go
No,
to
she does not.
quote the Commonwealth
She has the right to pick a different one.
on the transcript.
You
I
do
am
not have
on
the right to
page
speak
16,
corrupt lawyers. That's not how it works. Sorry.
line
Keep citing that.
18.
You do not have that right.
Obviously, and by the way, this is toward the very end of the 18. Obviously, the Commonwealth is in no position to contact, et cetera,
We know. We heard that already. Thanks.
and
10
who
times.
does that relate to? If Your Honor would go back to page 60, line 13.
Oh my God.
I don't, and it's a repeat, but I didn't get to the point here.
You don't get to the point on anything.
Witnesses testify at trial.
You didn't get to
I
any
don't care
point.
about their opinions, but I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to
Yeah,
discovery.
we already read this.
Key line. So if they can produce the discovery, I'd welcome ARCA. I want
He's
to
not
repeat that.
gotten to
You
us.
don't need to
I'm
repeat
sorry.
it.
Okay, so my point is, we produced the discovery.
No.
Why is there still an issue with ARCA? These aren't my words.
All right, done.
So
Brennan?
I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14.
That's not what you're arguing right now.
There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended
You
or
forget
collateral
what you're
damage
arguing
to
right
ARCA
now? You're not
still
arguing
gets
the Rule
to
14
testify
right now.
because it's a key part of the defense here.
But we're not arguing.
Now
No, I
to-
can't. I literally can't. Judge, get them all back on
the
track
Sixth
here.
Amendment. The
Hurry up.
United States Supreme Court
You know, the right to a public trial and the right to the
has
chance of her
held
choosing. Not if they
repeatedly
lie, you don't.
that
They have not
a
held that.
defendant's Sixth Amendment right to defense counsel of their choice
Unless
is
they lied.
a root basis of the Sixth Amendment.
Not the way it works, bud.
Is it an absolute right? No, Your
No.
Honor. If counsel does something so egregious,
Then you can be booted.
doesn't correct it,
Are you arguing for or against yourself? I'm just wondering. At
the
this point,
Sixth Amendment gives way
it's not
to
absolute.
the need for the court to have candor,
Fairness
the
and
need
candor,
for the court to have decorum in the courtroom.
which you
So
don't.
I understand that.
Do you?
My presentation today was as an advocate, of course,
Was a
foremost,
joke.
but also to provide all the information.
But you
So
didn't.
when Your Honor balances that sacrosanct Sixth Amendment right
She's gonna laugh.
with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez Lopez, 548 U.S. 140.
The fact that he's citing this case right now is fucking hilarious to me.
2006. And in that case, there was
Gonzalez Lopez,
violations
2006.
of the local rule.
Not like this.
And the court, in the court
Does
struck
not apply.
their counsel for that. And the
Is
US
that counsel pro hoc vice, or is that?
Thank you.
I'm gonna get to that. The answer is the counsel. I want to be
No.
sure of my
I'm
answer.
pretty sure no.
Yes. And I'm going to read
Wait.
my conclusion because it
Hold
doesn't
on.
say pro hoc vice, but I'm going to read you.
No, yeah, as far as I know, it does not say they were pro hoc
During the
vice.
hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100%
So
sure.
you just said yes.
Uh,
So you made a
and then
misrepresentation
the
of the
following
court.
week,
No.
et cetera, and then the revocation occurred. And yes, it was.
He's sleeping.
So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a
No.
revocation of pro hoc vice.
No,
There's a
it
difference.
wasn't allowed
There is
in
a
Obviously.
difference in
because
both
he had already had a
cases.
violation.
Okay.
There was both. Good point, both.
No,
So,
it's not both.
So, Your Honor,
It wasn't permitted.
and there
to-
are other cases when you have the Sixth Amendment,
Oh my God, dude, we
The
heard
fact
it already. Shut
that
up.
someone is pro hoc vice status is not the determining factor.
It's part
The
of it.
Sixth Amendment, in terms of legal dignity, is way up here,
You
and then the pro hoc and the local rules are down here.
no.
It's only when the violations
Oh my God,
that
he's so bad.
undergird the pro hoc vice get repetitive,
No.
more than repetitive, but go to things that are done that aren't corrected.
Mm,
And the issues that I've seen in my research, Your Honor, is that they have
What
to be
research?
the violations have to drive so much to the core issues in the case.
No, they don't.
It's like
They just
suborning perjury.
no. There just have to be a
putting people
violation.
on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And
No,
why
it
is that, Your
doesn't.
Honor? Because
You
the
said that.
court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial
No.
so that
Nice
there
try,
is
though.
not for the trial the bleeding in of those issues into pretrial matters.
Bro.
And the case law, there's a mention of that all the time. It encourages the trial courts
Now
to
does
make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely
Oh my God, he
affected
just said
by whatever
defendant.
the counsel may or may not have done.
I'm dead.
But
God,
I
he
want to
just
be very
doesn't
careful
stop.
and clear, Your Honor.
On
I'm not
and
saying
on.
that is sort of like mitigation. I'm saying, importantly, the
No, I
time
want
I
to see your
spent that
face.
there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor.
Good.
And I would
Shut
urge
the
the
fuck
court.
up.
Oh, finally.
He's still talking.
What happened
Oh.
on February 18th? There were some misstatements and they weren't cured. I don't want this to turn into, and I'm not
Please.
making
You're making a
this argument.
pissing
I'm
match.
not making an equivalence.
You are.
argument.
We knew
I'm
you were
not
going to
saying,
try to do
okay,
that.
now let's turn to the Commonwealth.
Called it.
To the contrary, Your Honor, and I hope I've provided a factual and legal basis.
You haven't.
I don't
Sorry.
want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued statement.
Unless you want to
scrutiny
be
of the defense
pissing.
counsel. And I don't say it as a camouflage or a shield.
Stop it.
We've got a lot to do between now and April 1st.
Not you concluded. Shut up.
The last thing I'm sure the court wants or anybody wants is to have something happen
Well, we
where
don't
that
wanna
date can't be
prolong
met
it.
because of whatever actions
that's
come
life.
out of this. My hope is that
That
we
you
all
will listen
understand
to
we
my
made
nonsense.
mistakes. Mistakes have been made clearly by both parties. And I
What?
would urge that the
Stop it.
parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are
Rich
important,
coming
which
from
is
the
how can
defense.
we prepare
That's
to make
so
sure that the
desperate.
presentations to the jury
Work with us, please.
candid,
We know we're in trouble.
truthful, and most importantly,
So desperate.
effective so that jury can make the best decision. There's a
So
lot at stake here.
desperate.
The issues are momentous,
Yep.
and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, that Your Honor has
You already
any
concluded.
concerns,
Shut
I
up.
would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can and certainly can.
Dude, shut
Thank you.
up.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
Oh my God.
What does she need to know? She just came back an hour ago.
She probably has to pee and she needs to go get Listerine for her
You are
ears.
muted.
Or she needs to go make several eye rolls. Several eye rolls. So I will tell you this. That
I
was
thought she already made her ruling, though. She was supposed to give the ruling today.
I don't fucking no. I think she gives them like, a chance to be heard, but she's already seen it. She's seen the evidence
Yeah.
for herself. So it's really not like their presentation doesn't really mean dick. Like you can mince words, you can dance around it. Do you think if I knew, right? If I knew that they were going to go in and go, well, the Commonwealth did this and word salad some shit. And that's not what he really meant. And what he said was, and what he didn't say was, we all knew that they were going to do that. That is like, it's right out of their playbook. We 100% knew. She knew. She knew. You know what I'm saying? She knew. She's not an idiot. She knows what they're going to try to do. There are many times in this case where they have made misstatements and completely lied, and she let it slide. What about the statement they made that the federal government said they cannot let this go to trial? And then the federal government had to come out and make a fucking statement that night saying that is not true.
Wow.
That is a lie. And the federal government said so. And she did not sanction them for that. She has given them plenty of grace. Now we're in a whole nother realm. Okay. The fact that he sat there and went, I would urge both parties, not the court, but both parties to take a deep breath. He's basically saying, work with us, please. We don't want one of our lawyers to be sanctioned, and you don't either because it will delay the trial. Like that was the most desperate thing I have ever seen in my entire life of watching 26 years of cases. That was the biggest word salad of nothingness. He argued against his own arguments a multitude of times. He insulted the judge's intelligence. He insulted what the judge, you're going to tell the judge what she meant by the words that she said? That's pretty fucking stupidly bold to do that and insult the judge like she's a moron. Like, He just spit in the court's face, essentially, by trying to remain polite. Well, and trying to like throw some like, you know, compliments in. The court knows what they're doing, blah, 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 blah. After I told you that, you know, you can't be like, oh, give compliments about the court knows what they're doing, but then also sit there and say, well, Your Honor meant when she said this. I think Your Honor knows what she meant when she said it. I also think she knows the definitions of the words that she said. She doesn't need you to tell her. But I mean, that was so bad. I'm sorry. Like, I wouldn't hire that guy to get me out of a fucking ticket. Like, what the? That was insufferable. Insufferable. Like, no wonder she needs 10 minutes. The fucking actual fuck. Like, I literally can't. And that's another thing. Val's right. Maybe she should take a charge of, and one thing the court does not like is they don't like pissing matches. So if you get in trouble and then you go, well, this guy did this and this and this and this, it's a pissing match. Courts don't like that shit. They don't like it. They want you to answer to what you did. They don't want you to have a pissing match about what someone else did. Like, that's not, I mean, that's like lawyering 101, bro. Like, that's why I say, I don't know how long this guy has been practicing for, but it doesn't really seem like he knows what the F and F he's actually doing here. Like, that was completely insufferable. Like, I honestly don't understand. Like, I mean, Brennan's going to have time to respond. And since he likes to make sure that he can get it all out, let's hear what he has to say, because I'm ready for it. But of course, it's 3:15. So like,
I'm guessing we're not going to get other motions today.
Probably not. I'm guessing probably. I mean, we might get to maybe one, maybe, possibly get to one. But that's a big fat maybe. Like, but I will say around between 3:30 and 3:40, I'm going to mute myself and shut my camera off because I got to go grab my kid off the bus outside. So it's going to take me like 3 minutes to go down there and get her and come back up. You guys can handle that for like 5 minutes, right?
Oh, I'm sure. If not, you'll come back and punch it down.
Yeah. Just so insane to me. So insane. Like, took all that time to say a whole lot of nothingness. Absolute nothingness. Like, bro, what just happened? Like, you argued against your own arguments. That's another thing. I think that is something that Hank might be bringing up. That Mr. Alessi has a connection to ARCA. He's on their board, I believe, of the parent company. So I find it funny that he's the one that gave the arguments. I thought we might hear from Jackson himself, but considering what's he going to say to the judge? Like, you're not going to be able to word salad what Alessi just did. Like, he would have had to lie to the judge to her face boldly instead of trying to word salad around answers. Like, that's what there's a conflict here, in my opinion, a huge conflict. And I want to see if Brennan's going to bring it up or not. We'll find out, I guess. I'm not sure. I'm not sure. I'm guessing Hank does, though. So we'll see. I mean, I also want to hear about the federal investigation. I want Brennan to out that, and I'm sure he will, because he knows what they were trying to do by run out the clock. It took him, Alessi, all day to literally just read transcripts. Like that's all he did was read transcripts and then tell the judge what other people meant when they said what they said. I mean, that was a waste of hours, 4 hours and 35 minutes, probably. So an hour. So for lunch. So 3 hours and 35 minutes. Waste to hear Alessi say basically nothing other than, sure, mistakes were made, misstatements were made, but whatever. The Commonwealth made some. No, they didn't. And they corrected the record right away. If they did, you people took a year. You've had all that stuff in your possession for close to a year, and you did not turn it over. You were hiding it. Let's get real here. You had no choice but to turn it over. Like, come on now. I just can't. It's like, it's so insufferable to listen to that man. For me, it's like, maybe if he had a good argument, a good excuse, anything, but he had none of that, none of it. Like, come on, man. Like, yeah, I'm getting messages of people who are like, dude, that was like, I couldn't, like, I don't even know how I just listened to all that. And that's the sad part, is like, people don't even know how they listen to all that. They're like, what in the fucking fuck? Like,
I can't tell you what I heard. I really can't tell you what was said today because there was just so much gobbledygook.
He said a lot of the same things numerous times, which once again, we all knew he was going to do because that's what he does. But like, the conclusion, Your Honor, and you have a conclusion.
He lost me a long time ago.
Like, bro, I listened to everything that he said, but like, the whole point of that was to like confuse. But like, the judge will get a transcript, so like, who are you confusing other than the judge? And she gets a transcript if she wants it. Like, and then blame the court reporter. That was a good one. Let's blame the court reporter. Let's blame everyone else but the defense for their dirty shit. Y'all lied to the court. It's simple. The judge has the statements you made to her. She has the evidence those were not true. It's not hard. Like, and then further, Jackson went to the media when he left court that next day, and they asked him if that bill for $23,000 was paid, and he told them no, absolutely not. Lie detector determined that was a lie. You're going to say you didn't know? Your office paid it, but you didn't know? Is that what we're going to go with? Come on. Stop it. And then to like throw in like, oh, Mr. Yannetti basically didn't know. That's what he went with, basically, was Mr. Yannetti wasn't in the email chain, so he didn't know. It doesn't matter if he knew. It's his job to know because he is sponsoring a pro hac vice attorney. He signed something saying that he is going to make sure that that attorney follows all the rules and regulations and laws of the state of Massachusetts. It's his job to know. He can't just claim he didn't know. He's still responsible, regardless. I think that completely sailed right over Mr. Alessi's head. Doesn't matter if he wasn't in the email chain. It is his job to know and to make sure that that attorney is following all the laws and all the procedures of Massachusetts. It's not rocket science here, people. Hold on a second.
Papa Gino's? Is that anything like Papa John's?
I have no idea. I don't eat Papa John's either. But that, I don't know. That's making me hungry, though.
No, not really.
Yeah, not for that stuff, though. That don't even look good.
That really didn't look good. I don't know.
Yeah, doesn't make me hungry for that. I want a sub. Okay, look. No bulldog right now. No, sir. Flaps, that hurts. Sir Duke. Seriously, you're going to rip your cardboard thing apart. He has a clawer. Because if he doesn't have something to claw, he'll find something to claw. I've never had a cat like that before. My cat's never damaged anything in my house. I've had cats all my life. This cat will trash your stuff if you don't have something to claw. So I buy him this thing. It has refills. It's like this cardboard thing he can claw. He makes a hell of a mess with it, though. It's always everywhere. Like, Jesus. But it beats, I'll spend $4 for that instead of him clawing my couch or something.
Right.
Sorry, my sister called.
That's okay. It seems like a long
All right,
time.
we charge by the minute, so that's $195.
I know, right?
$1.56.
No, thankfully she's going to take me to go do some laundry because I have to go to the laundromat because I don't have a washer and dryer in my apartment. I wish I did. Basement doesn't have a hookup, so yeah. It's a pain
The
in the ass.
laundromat.
Oh my God, I can't. And like, it's about affording it, dude. You know what I mean? Like, I can only do what I
I
can
have a
afford
washer
to
and
do.
dryer sitting out my garage. If you live close, I'd give it to you.
Right? For real, I'd take it. Like, could hook it up right in my apartment, dude. I'm telling you, I'm thinking about trying to get one of those ones that hook up to like the sink. You know, it does a full load, the washer at least. But
Okay,
again,
you guys, this new microphone, I am going to have hours of fun with this thing.
We're doing Julie, and you got to come out as Julie, man. You got to have your glasses on, your blonde wig.
That's exactly
And
what
who we're talking about, Twisted Tea. This woman is freaking. She's, and I'm being nice, calling her crazy. I really think the FBI has a file on her, and she's going to be getting a knock on her door on a welfare check only with a 5150 in hand. This woman emails them 30 to 80 pages repeatedly. Oh, she gets on here. She does these raps with this microphone she bought at Five Below and says the nastiest vile things about the parents of a missing kid.
What is wrong with people? Like, really?
Oh, the stuff she does. Then she went and dug up all her childhood trauma. She her biological family, it was a bad situation. She was removed, they were arrested, you know, the abuse shit. This woman went and dug up all the court documents and stuff on her biological family and read them all out online and doxed everybody and re-victimized, telling everybody what happened to her.
Dude, I was a kid in foster care, and like, why? Why do you want to make people relive things like that? I don't understand. Why?
Oh,
because because her son's missing.
Yeah, that doesn't give people the right. People suck. Let's see.
All right. So before I hear from the Commonwealth, Mr. Alessi, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, and you said I could ask questions
next week
of other counsel.
Well, they have
so,
two dates next week.
Fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti. As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
When you knew it. Yep.
No, what he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
The court did after it looked at the transcript.
No.
We all remembered it
long before I looked at that transcript.
We all did.
The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript was very clearly the federal.
Exactly what you meant.
Yeah, he's a liar.
Is the federal.
I
did not have in my head at all emails, communications.
Oh, please stop it. You expect her to believe that? She's not going to believe that. Sorry.
Number one, he knows every one of his witnesses that have been deposed or that could possibly testify.
The federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information. Background information.
That didn't age well for you.
The ARCA experts. That was it.
Your Honor, if I could disagree.
No, hold on.
Oh no! Don't give it back to him, please. Don't give it back to him.
Please, that you're responsible for all discovery. But the same question for you, and again, you don't have to answer. But is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor. I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy
Should have already
the
looked.
10 things that were outlined.
Your
by Mr.
job is to
Brennan.
already look. So
Okay.
that's a shit
So
excuse.
I'm
Sorry.
going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Yes. Thank fucking God.
Mm.
Here we go.
Come on, the states doesn't really need to do a whole hell of a lot, no?
No, they don't. They don't need 3 hours.
His argument, talking about the Sixth Amendment
Can't hear you, Bob.
and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations.
Bingo.
1.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing of materials that there was information that showed that ARCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alisi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane.
Yep.
We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanches started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know. A voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been
More communication.
in that time that
Correct.
rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask.
So just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Lisi.
It wasn't a request, Your Honor.
You suggested that I call them.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor did.
I'll move on, but the point is, it is
Good.
not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement.
Bingo.
There's no contrition, and there's no confidence that we are going to get all the materials that we're entitled to. To suggest that Archer's position did not change, it did change. Their opinions did change by the time they reached trial. It is not.
Did the defense try to pull that stuff during the trial that they didn't get everything from the prosecution?
It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents were provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my TUI requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, Voire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly.
Since Levy was out.
No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth a motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office, it gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf and the invoice for billing. Now, I did misspeak. I corrected it, but it is not the source of that information. It is the substance of that information, what is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Yannetti. He's a fine attorney, an excellent attorney who I admire. But there is a responsibility.
Bingo.
So that there are not a number of pro hoc vice lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on word to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now,
As throughout the entire case.
Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal materials.
I'll be right back, you
And there
guys.
was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over there, please. All right. If I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure.
Oh, they don't want, why doesn't the judge have the protective order?
I'll need to call the United States Attorney's Office and get an answer from the court.
All right. I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26.
No, I know that, but what date?
June 5th, 2024. Discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right. So you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's Dave.
It is Anna.
What's the volume number and the page number?
day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi suggesting
The grand
somehow
presentation.
that this was open and notorious is not backed up by the defense attorneys themselves.
Nope.
The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts from ARCA, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second. Let me grab that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what.
Third must change
Notice
the mind.
3 experts. So there must be
Or the third
conversations
has a
with
different
somebody
opinion.
explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On on June 18th, 2024, the Voire hearing. The court asks, well, I thought...
What page? I've got the transcript. What page are you on? Do you know?
No, but I can,
If it's just your notes, that's okay.
I can pull it up, Your Honor.
Yeah. Crawl back into that corner you guys are in. It looks very bad for you.
Oh, he's done. I had to step away for 2 seconds to take my husband's phone. Is he done?
Like, look, no, he was giving her the page number.
I've never seen a judge operate the way she does as far as time and stuff.
Line 11.
And at times it did seem like she would
So the
rush.
understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that. And you say you haven't been able to even talk to them at all about this case.
See,
And the answer is that's correct.
that's another lie.
Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the Voire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, have you and I ever met face-to-face? No, sir. Now, this illustrates an important point. That is technically true.
He was mincing words.
That making to the court and to the Commonwealth. Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce
That he was lying.
Defense and ARCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions for dare in a trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement.
Correct.
It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over.
You have to tell the Commonwealth.
There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence or information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice date of July 12, 2024. It's addressed to...
Hold on. You've got a long to-do list. Thankfully, you have DoorDash, and top-rated shoppers will deliver groceries right to your door as if you picked them all yourself. Put your groceries in good hands. Order all your groceries with DoorDash.
For this expert, other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation.
Ouch.
The witnesses they were going to call expected that they were going to be paid by the defense, or they wouldn't have been keeping track of their time.
Correct.
Back on May 1st, 2024, participated in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer. And then the 24th
Almost a payment.
saying we need to take a step back because the U.S. Attorney's Office.
22nd, I think.
Sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing where the representations were made, there was a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know.
Ouch.
This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony and trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track for the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talk about correcting a record. And so this $23,925, we find out today it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit. We have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation. Nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story, a fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality of representations made in court, we also At some point, we're going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I'd suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent. They had their opinions and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question's going to be, why? Why did they improve? Why did the
particular page you'd like me to look at without
if you look at the first page,
Yes.
if I can have a moment.
You don't have to read any of it. You just tell me what paragraph.
Yeah, I believe it's just the first paragraph that lays out their findings.
Thank you very much.
I'd actually particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page,
Okay.
which is signed by all 3 of the experts, Mr. Wolf, Mr. Rentschler, Mr. Klein, says essentially the same thing.
Okay.
So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there is no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it. And the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARC experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled.
Probably not even then.
Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
Ouch.
All right. Thank you. Mr. Lessie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points.
You don't need to know a wholesome. You gave a wholesome response already, Bob.
Yeah, really.
Focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they had been retained by the government.
Probable or is?
By the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to provide
Bullshit.
testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense
Bullshit.
expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And in the entries, all that Mr.
Have their own separate agreement with the government.
There is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to...
You spent 3 hours saying nothing.
He made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to.
Yes, you do.
He
You have all the
referred to,
transcripts.
Of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court.
We're talking about whether that bill was
To be
paid.
clear, the reporter asked, did you pay for testimony? Did you pay for testimony?
Oh, please,
Mr. Jackson,
we're
of course, said,
mixing
"No,
words."
I paid for their time.
Did he say I paid for their time?
No.
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond
please.
exactly the same way.
Right. So you just told I paid for their time. That was not said, right?
That was not said, but
All
I'm
right,
saying
that's what
there's
I just
always
asked.
some inference about being what he said, that what was said, but that was his response, that was it. But it was the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARPA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I will go back to the transcript.
You can go back to the.
Yeah,
transcript.
there
Earlier
was
on,
3
there was a
ARCA
discussion
people. They
way
excluded
early
one.
on.
Who is Mr. Klein?
He was a third ARCA expert.
What she just
that
asked.
Was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
When let me be clear on what I made by retain. He didn't testify.
It's been a long day.
I'm trying to answer your question.
I know, and I realize that you just said something that you want to explain. Go ahead and explain
So,
what you
so
just
what
said.
I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler.
But why is the question?
And that's what I want to come to.
They have the right to know.
The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use.
Thanks for admitting a bias, dumbass.
You're going to be having them testify. Anybody could claim that testimony is biased. But the point is, Your Honor,
you just said you're not going to say that there wasn't.
That somehow mysteriously this third person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses, because we weren't talking about the third. The third was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said
no,
you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Ms. Giannetti, that's who I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part.
That was her point, you
Brennan
idiot.
didn't read the rest of it. You're to believe.
So where are we? Are we the June 10th, Ms. Giannetti?
Your Honor, June 10th. That's exactly right. That's exactly right. Was June 10th. It's important. He stopped.
So it's page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is
definitely single.
That you've never spoken to, and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined and detailed in the reports. Your Honor, that's 100% true.
You read that earlier.
Right, but Mr. Brennan just
I don't need you to say it again. And you mischaracterized him.
because that is 100% true.
Shut the fuck up.
Like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor.
Yeah, she gets that you're an idiot, and she's rolling her eyes in her head.
Talked about that they're,
I would be. I'd go back to my chambers and roll my fucking eyes.
Improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions and follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Chronological was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails.
Bullshit.
So I asked Ms. Little, who would, between the two of them, would, if there was any record.
Right, and they speak on their own behalf.
During the break, I asked Ms. Little, I said, Ms. Little, when you heard and got the order, because that's the first she knew of the inquiry, she gets the order. I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails?
No, he's not
And
right.
she said,
And his legal
no,
argument has no
I
teeth
didn't recall them. I didn't
at all.
remember their existence. And what I did was I knew we had to turn over discovery. I then went back.
They've had
I
it for a year,
discovered,
almost a year.
rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3.
Had it since the last trial, it should have been turned over before the last trial.
At the time Mr. Jackson made those statements and recalled those emails, neither did Miss Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions.
She's not an idiot. Thanks, though. But
Conflating
definitely
them
keep patronizing her.
The analysis, and my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diazzi. It involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable. And yet the court held that you could not disqualify them because of the Sixth Amendment.
Was not pro hoc
Your Honor, is
vice.
when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty
False.
in the determination of balancing the Sixth Amendment.
False.
It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant and their choice of counsel, that is a much different analysis with the Sixth
You
Amendment.
don't have the choice
So I
of
will stop
counsel
there,
to
Your
be
Honor.
corrupt and
You
lie.
said the
Period.
brief I wanted. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly.
Sure.
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation
Yep.
and short reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed
On
late, right?
February
On a
16th.
Saturday or something.
February 16, 2025. This sums it up, really.
Oh, this is the motion to
Signed by
dismiss.
Attorney Jackson, Attorney Alisi, Attorney Yannetti, certificate of service by Attorney Little.
Is it signed by Ms. Little? It's not, right? It's
Only done the
maybe
certificate of
authored
service.
by, okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yannetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion
You knew it.
to
Dismissal.
exclude employees of ARCA LLC. And here's the representation.
Okay,
made.
maybe it's not the motion.
Not
What
my
is it?
words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt.
They just
to
wrote
separate
this.
Testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Lisi no longer likes the word retain, but that retain word has import. The reason he said it. Their words, their motion is no different than the tone of representations made February, last June, May, and before. Thank you.
All right.
Ouch.
So we're back here next week.
Hammer.
I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know,
is not letting
Mr.
me.
Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at
What time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9. Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course, I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
Well, folks,
No ruling.
Hank just dropped the hammer. That happens. Yep, sure did. Hold on, let me get rid of this thing here.
I was really hoping for a ruling today.
I know. She'll give one, though. Probably before next week, I'm guessing. Before next Tuesday. I mean, it's so bad for them. Bottom line is it's really bad for them. They just filed that motion on the 16th of February, late on a Saturday, and stated in their motion that they did not pay ARCA. Yeah, you did. And they knew that by that. And that was Hank's point, which is by that day, they knew. There was no ifs, ands, or buts. You know about the bill. You know that you paid them. And Mr. Jackson told the media, of course not. He lied. You can mince words and say, of course not. But what I meant was I paid for their time, not their testimony. But let's get real here. That is not what he meant. He meant, no, I didn't pay them at all. Like, you paid them. He thought he was going to get out of it somehow, realized there was no real way out of it after reading the transcripts, and was like, well, I'll just say what I meant was. And funny enough, isn't it funny that the cult comes up with these excuses before the attorneys ever even have a chance to? And then they just read online and they go, one of these people will come up with an excuse for us. And then they bring it to the court, except it doesn't pass the smell test and it doesn't pass the evidence. So then Hank has to bring forth the pieces of evidence that show that that's a bold-faced lie. Like, y'all just filed that motion. Just filed it. Like, no. Like, y'all just said you didn't pay them and you paid them. And that's not saying, oh, we paid them for our time or we paid them for this or paid them for that. It's just you paid them. You paid them or you didn't. And you're saying that you didn't when you did just a couple days ago.
Kathy, did your mail arrive?
Yeah.
Did you get a package today?
No.
Uh-oh.
What the fuck?
I don't love anything more than surprise packages. Just that's fucking awesome.
I know what it is. She made a cake topper for my son for his birthday cake.
Oh, I love
I can't wait to
that.
get it.
And I got her girl some jewelry.
Oh, I love
Yeah.
that. Oh, my little one is like, she's a diva. She makeup, jewelry, you know, that all that. It's, you know,
Oh,
she's
yeah.
17 on 30. So see.
Oh.
Well, this is pissing me
Damn,
off.
I got. If you don't mind me, I'm gonna put something in back chat for you, Twisted.
Sure. Check the tracking on it. Voices.
I'll get it tomorrow. I always get it a day after they tell her it's coming.
Oh, that's annoying.
It's just how it works.
That's the thing. Like the tracking says it's set to be delivered today, but it's just the way this works out here. I can never.
To be fair, USPS, the regular mail, is like notoriously slow. And like I've had 2 packages that they mysteriously just sent back to like the company for no reason whatsoever. It's for no reason. But I will say this. That was ridiculous. I will say there's no teeth to anything Elise said. Not even close. Not by a freaking long shot. I will say that he said a lot without saying anything at all. He said a lot of nothing without saying literally anything at all whatsoever. Other than blah, 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 Your Honor, the Commonwealth, blah, 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 we didn't do it, blah, 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 like all that nonsense. Like he said, he actually shot himself in the foot numerous times, argued against his own argument numerous times, and in the end said, I'm not going to say that they're not biased, Your Honor. Well, that's kind of part of the question here. So thank you for saying you're not going to say they're not biased. You absolute dum-dum. Like, thank you very much, sir. Like, it took Hank 1 hour to literally piece apart the word salad of 3.5 hours of listening to Elise ready to like gouge my eardrums out, like legitimately. So, I mean, that was insufferable having to listen to him. He didn't make any valiant points. They were all over the place. His timeline was everywhere. Hank was like, this day, this time, this day, this time. And they knew this, when, and this is, and that's what the judge wanted to know ultimately. When did you know things? When? What did you know and when did you know it? That's what she wanted to know. And I think Hank just gave her the answers. And also in that motion that they just filed to say you didn't pay them when you know you did, to lie to the media outside, that ouchies. Hank just dropped a serious hammer on the defense. Now, all we have to worry about is waiting for the docket. And as soon as it comes out, I will post it on Twitter, waiting to check the docket for any sort of decision she makes on what she's going to do with this. So that's our catechism about done anyway. But I did say in back chat, I don't know if you saw it, 7/8. But, oh, I'm glad the kitty's good. Oh, I love that for you. Little fur ball. So I'm going to wrap it up. I got to go do some laundry. But obviously, thank you guys for coming.
All right. Well, I guess we'll meet back. We'll reconvene next Tuesday.
Yes, ma'am.
Don't forget to cancel that StreamYard.
I will not forget, because then I can redo the regular, like cheaper one when I get paid on Friday.
All right. We'll see you
All
later.
right.
Bye.
See you later. So yeah, that's pretty much what we had for you guys today. I got to do some laundry. Of course, thank you guys. Obviously, as always, I missed you guys. We will reconvene Tuesday, Wednesday, and Friday, it looks like. So, hopefully we don't have to listen to too much of a Leslie, because if we do, I might smash my head off a brick wall. So let's just hope and pray that like Beb sort of like cuts him off or like gives him a freaking time limit, because if she doesn't, he just takes up the entire day with nothingness, literal nothingness. If you feel so inclined that I had to listen to that all day and I was ready to bash my head off a wall, and you want to support and you're on the replay crew, the channel, the information's down here, Cash App, Venmo, PayPal. It's always welcome and it's always appreciated. At least on my channel, it is. I love you guys so much. And I hope to see you all. Love you too, Brie. Hope to see you all on Tuesday. And until then, I will be on Twitter so you guys can check out what I have to say over there about all that. All right. Love you guys. Bye.